So which one of these are you connected to? I don't know why I'm booted. This one. Okay, thank you.
Wrong day, wrong courtroom, wrong year. 2022, man, I'm late. Yeah, there's a judge who wants to talk to you.
I've seen you before. I'm tired.
Clearly. Do you know where you need to be?
Wrong year.
Wrong year.
They, for some reason, they came back up on my.
Seriously. Oh my gosh. All right, go to bed.
Never checked.
All right. We've got Ms. Rivers. Good. We're ready to go. All right, folks, let's get started. Happy Tuesday, October 17th. Phillies up 1-0 over the Diamondbacks. Let's work through. We've got a plea and arraignment calendar. We also have a plea this morning. Is Mr. Richardson here? He's not here. So when he gets here, we can pivot to that plea. I got your email, Ms. Clark, with all the details. So hopefully that's ready to go when we get that lawyer. So let's work our way through the plea and arraignment calendar. I think there's also a plea on that. And I see Mr. Wright has joined us. I think we need a connection with another facility, but I'll wait till we hear from Ms. Nelson about that. So position 1 on the plea and arraignment calendar is Samuel Lopez. Is Mr. Lopez here? Or is he in custody? Not in custody. Who represents Mr. Lopez?
Would be mine. It looks like he was released in June of 2022 to DOC.
Oh.
It doesn't appear from what I can pull up that he's currently in DOC,
Okay,
but I've not had contact with him, unfortunately.
got it. Let's look. Good morning. Ms. Clark, do you know anything about Mr. Lopez's situation?
No, Your Honor.
Okay. Let's see, there was court in mid-2022, indictment handed down in August. Okay. Your best read of the online information, Ms. Feely, is that Mr. Lopez would be out of DOC custody now.
So from what I can pull up just from the public page, there's sometimes some inconsistencies, like if he's on first offender or something like that, but I can't verify that he's in custody.
Okay. All right. We've got an address. Ms. Clark?
Your Honor, the state requested bench 1 lawful.
Okay. We'll do that. It does say transferred to DOC from his 21 case after spending almost 300 days here for a different armed robbery allegation. So we'll do that. And Ms. Feely, if you are able to track him down and there were understandable changes of address because he was in DOC custody and the DeForest Ferry address doesn't work, we can always do a walk-in, but I'm going to get the bench warrant out there. So we've got something to reel him in.
Thank you.
All right. Tiffany Turner. Also your case, Ms. Feely?
I have not been able to make contact with her.
Okay. Is it one of the, it's a 23 indictment, but it's an ag assault. So this could be conduct from
March of 2021.
Okay. All right. But you haven't had a chance to reach her. There's a bonding company. Ms. Clark, bench warrant?
Yes, Your Honor.
Okay. Douglas Harston is in custody. We're holding for Mr. Abate, or you're covering it?
It's my case.
Oh, it's your case. All right. I saw Ms. Miller online, so Willingham.
That's my case, Judge. Good morning.
Good morning. There you are. All right. Mr. Hairston is here, so we're going to bring him out in just a second. Are you waiving arraignment for Mr. Hairston, or does he want to be formally arraigned before we talk about bond?
No, Judge, we are going to waive formal arraignment and plead not guilty. And on the topic of bond, Your Honor, I emailed Ms. Nelson this morning that we are not actually prepared to go forward with our bond motion today. Mr. Harston and I met last night for a long time, and we would be requesting respectfully a reset of the bond motion.
Sure. Let's bring Mr. Harrison out. We'll cover all that so he can hear it as well. And we'll go from there.
Yes, Your Honor.
And Judge, I do have the victim's family present. I understand Ms. Miller's need for a reset. I would ask that I have an opportunity to confer with them because I know her father traveled from New Orleans for today. So I just want an opportunity to try and speak with them to see what a good date would be if we're going to reset this.
Definitely. And I'm happy to hear briefly from them if there's something they want to share. But more importantly, if there is, because a reset is being requested, we'll make it work for everyone's calendar. So obviously we'll need Ms. Miller to hear it. Hey, Mr. Harrison, if you just come right up to the podium, please. But it's two-way street. So we'll make sure that we get a few dates that work for Ms. Miller, but they'll also need to work for the family of the deceased. Whether that means they appear virtually, which is always okay, or if they want to be here in person, which is their right. So we'll make sure we accommodate both ends of the equation. Okay. Thank you for flagging that. Good morning, Mr. Harston.
Good morning.
I'm Judge McBurney. Your case has been assigned to me. Your lawyer is on the screen there. I'm going to add you to the spotlight so she can see you pretty clearly. Ms. Miller explained to me as we were getting you brought out here that you and she had a good conversation last night and that we're going to tap the brakes briefly on discussing bond, which doesn't mean you're giving up any bond argument at all. It means that you and Ms. Miller want a little more time to think through either what you're going to present or argue or who knows what. And perfectly acceptable. You're not forfeiting anything. Ms. Miller has simply said, could we do it at a later date? And I was having a conversation with the prosecutor as you were coming out. The answer is, of course we can. We just need to make sure that that later date not only works for Ms. Miller, but also for the family members of the deceased, because they have a right to be heard. Anytime we have a proceeding, they're likely going to have a perspective on whether you should get bond or not. And that doesn't control what I do, but it certainly informs part of how I weigh all this. So we were going to do two things. One was talk about bond, but we're going to postpone that a little bit. And the other thing that does happen today is your day for an arraignment. And Ms. Miller has told me that you're waiving arraignment, which simply means I don't read into the record what all the allegations are against you and what the penalties are. You're charged with murder and a bunch of related offenses. And the penalty for murder is life. You know that, and you and Ms. Miller have discussed that. I'll be signing a scheduling order today or tomorrow that starts the case moving along. That will require the prosecutor, who's Ms. Willingham, sitting behind you, to get to Ms. Miller all the discovery that the state has, whether that's photographs of the crime scene, or I had to review the case file a little bit to get ready. And it sounds like you had some interactions with the police. And so if they wrote a report, Ms. Miller's entitled to that because, of course, you're entitled to it. So the state's going to get all that discovery to your lawyer. She'll share it with you. If it involves things that she can't leave with you, like a video, then I can get an order entered so she can bring a computer to the jail. This is assuming you're still in custody, and you guys can watch the video that way. But this next process is for the state to get to the defense all the information the state has, so you and Ms. Miller can start thinking about, well, how are we going to manage this one? Are there things that ought to be suppressed? Maybe there was a photo lineup done and someone picked you out of the photo lineup, but it was 6 pictures of you. That's not a real good photo lineup. And Ms. Miller would file a motion and we'd have to argue all that. She may look at the case and say there's really not something that we ought to litigate up front. And she's going to spend time working with the prosecutor to see if there's some way to resolve it short of trial. My goal is to get you to that final resolution, be it a trial and a jury will decide, or a plea, if that's what it is, as soon as we can, consistent with your lawyer's schedule and the state schedule. You're sitting in jail and you have a right to get into court to get that closure, just as the victim's family has a right to get closure. And so I'm going to move us in that direction, and we'll just work through things one at a time. So I'll probably see you next when your lawyer and the state agree, here's a date where we could talk about bond. Okay?
Yes, sir.
Any questions about what I just covered?
No, Your Honor.
All right, Ms. Willingham.
Judge, I did want to go ahead and flag that, we've requested some of the evidence with GBI be expedited. And I requested a November 1st date. However, in speaking with them, I anticipate it's gonna be closer to late December. So I just wanted to make the court aware that I do expect that there will be some DNA, evidence.
So I'm aware of that. I had to sign a warrant. You probably had a buccal swab recently, or you would.
That has not happened yet.
Oh, okay. I signed a warrant for the state to be able to collect your DNA because according to some affidavit, you were wearing a hoodie or a jacket or something that appeared to have blood on it. And everyone needs to figure out, is it blood? And if so, whose blood is it? So that's something that Ms. Willingham is talking about.
And
I
there's
think.
also ballistics that we are also waiting on. So once those things all get back, then we will make sure that Ms. Miller gets them. But I did just want to, I know that those are things that sometimes are beyond our control. So
Right.
I just wanted to flag that for the court.
No, I understand. My expectation is you'll get to Ms. Miller all those other things. So if there's surveillance video, there's surveillance video, and obviously all the reports other than any final GBI conclusions about DNA or ballistics. Ms. Miller, did you have any questions or any things you wanted to add?
No, Judge. I did get, though, in all fairness to the prosecutor, some initial discovery from Adam Abadi, who had initially appeared on the case. There are several things missing, as Madam Prosecutor has just noted, and I'm certain that she and I will work together to get all the discovery that we're entitled to.
Great. Okay. And certainly let me know, Ms. Miller, if there is a holdup in discovery that isn't making sense to you. We all get it that the GBI moves at its own pace, but if there are other things that ought to be produced, and I'm confident Ms. Willingham will get them for you, but I'm happy to engage both sides if something seems stalled. So Mr. Harston, as I said, I will see you next and everyone else in the mix, either to talk about bond or if your lawyer files any motions that are pretrial motions, a motion to suppress. If you had a conversation with the police, there may have been something about that Ms. Miller concludes wasn't consistent with your constitutional rights. And then we'll get the officer in here and he or she will tell me what happened and maybe you testify and then I have to rule on that to say your statement is coming in or it's not coming in. You and the state are entitled to know what's coming in at trial because that may shape your decision about whether you want to go to trial or not, or what a reasonable outcome that short of trial might look like. Ms. Willingham, anything else?
Nothing further from the state, Your Honor.
Okay. Ms. Miller, do you want to reach out to Ms. Nelson when you and Mr. Harston are ready for a bond hearing? Or how do you want to just look for something that's X days out, or should we wait for you to contact Ms. Willingham and Ms. Nelson to say, okay, we're ready?
Judge, it will be my preference to speak to Ms. Willingham and Ms. Nelson once we're ready.
Okay, that's exactly how we'll do it. Mr. Harrison, do you have any questions about anything I said?
No, Your Honor.
Okay, Ms. Miller, thank you for being here. You are free to go. Mr. Harrison, you will see your lawyer soon once she gets all that discovery.
Thank you, Your Honor.
All right. And Ms. Willingham, I'm happy if you, I know you want to talk with the victim's family, you're free to do that. They can say something to me if they want to, but I tried to make it clear that we won't do anything in terms of a bond hearing without making sure it works with everyone's schedule.
Yes, Judge, and I just wanted, the family wanted to make sure that it is heard that they've been here before and this bond motion was reset.
Here before, maybe in front of a magistrate judge?
Correct.
Okay.
And that's what I do plan to step out and kind of further explain that to them as well. But I looked in Odyssey and it appears it was on for a bond motion, but the case was then indicted. So it looks like it probably got kicked at that point.
Got it.
But I wanted to just make the court aware that the family has been present before. So they are just a bit frustrated that they are here today and that we're not going to have a bond motion. But I will also further kind of explain some things to them in terms of the possibility that the bond motion could then just be withdrawn and still refiled.
Yep.
So but I wanted to make that clear on the record that
Okay.
they have been here multiple times. This is Mr. Woods, this is the victim's
Morning,
father.
Good morning.
This is the second time I've traveled 550 miles away with my
Okay.
son. So I appreciate it, the court consider that and not grant any more continuances on bond hearing.
So I understand your frustration. I want to emphasize that your presence is noted first, but second, should this be reset? And frankly, a defendant can ask for bond anytime he wants. It doesn't mean that we immediately set the hearing without giving anyone notice. But because of that, I just want to reemphasize that if what you and your family elect to do is appear on screen instead, I can still see you and I can still hear you and I'll feel the emotion in what you have to say. And I share that only to spare you the expense and the difficulty of coming back here, not to discourage you from doing that. My courtroom is always open. And so you'll always be welcome in here in the same way that Mr. Harston's family could be here if they wanted to. But I don't discount in some way, their family clearly didn't care. They appeared on Zoom. I have folks appear on Zoom from Atlanta because they're having to step away from their job to say, Judge, you need to hear X. And then I listen to what X is. And if you're coming from 550 miles away, I'll definitely understand it if you're appearing on screen instead of in person. And the Zoom will always be running if we're doing something like a bond hearing. So you'll wait whether you want to come back next time. But I'm not able to tell a defense attorney, stop. You can't have your bond hearing because you continued it from last time. Now, if we have a bond hearing and I make a ruling, then I'm able to say, don't come back unless something's changed. The state's lost evidence and it's going to take another 6 months. We should talk about bond again. But if the state's moving the case along and I've made my bond ruling, whether it's no bond or $100,000 bond or whatever, we don't have to talk about that again. So there will be a bond hearing if and when the defense says we're ready to do it. I'm not able to say, stop canceling it. I know that's frustrating. I'm not telling you that so you can say, oh, I feel better now. But that may be a reason, given the history you've experienced, to say we'll connect via Zoom next time. But that's a very personal decision and I'm not pushing you one way or the other. Okay.
Thank you.
All right. You bet.
Judge, I have position 8. I'm gonna step out, but I'll be right back. Rodriguez.
Yeah, is Mr. Woods here? He is here. Okay. Do we know, it's just plea and arraignment. Will he be represented by the public defender's office or we don't know? Position 8. Who's your lawyer? Mr. Partridge? Okay. Is he going to come up here today?
He said he was.
Okay, then you should go next door. All right. Your lawyer is always downstairs, but we'll get him up here. Yeah, if you could just tell him whenever he shows up, we'll pause and handle your case while he's here, because I know he is needed down on the first floor.
And I am just next door.
Okay. Ms. Miller, are you still on? Nope. Do you mind bugging her? She said she's waiving arraignment, but she said it. And I forgot to say, would you file something? Thanks. Terrian Blank?
This will be mine. Unfortunately, I have not had contact with Mr. Blank. I believe he was released over the summer on this case.
Okay, so it's more recent.
Yes.
All right, Ms. Clark, the usual?
Yes, Your Honor. Thanks for my Bible.
Okay. Ms. Turner? Hey, how are you? Well, look at that. Let's cross out that. Let's rewind. Thank you, Deputy Gordon. To position 2. Ms. Feely, your client?
It will be, if she qualifies, so if I can have a moment to speak with her.
Sure. So Ms. Turner, if you would sit tight, we're going to get through this calendar pretty quickly. And then Ms. Feely needs to talk to you about whether you very briefly had a public defender, but it was at your first appearance and that was a long time ago. And so circumstances may have changed. You may now be the CEO of a big company and make too much money to have the public defender. Okay. So Ms. Feely will talk with you. And if you do qualify, then we'll take care of what we needed to today, but please don't leave. We also need to make sure we've got a good address for you. so that we're able to let you know when you need to be back in court. All right, Shannon Bowe.
This will also be mine, Judge, and I also have not been able to establish contact.
Okay. Your case, Ms. Clark, bench warrant.
Yes, Your Honor.
All right, Anthony Mitchell. And Mr. Lyle, it says PD next to Mr. Lyle, not a PD, private?
That's a conflict attorney, Judge.
Okay.
I think it's whatever the name of Metro Conflict is now.
Right. We haven't had a plea and arraignment in a minute. I don't see anyone online who is a conflict defender. Hey, we'll turn to your case in 1 second.
Let me reach out to Ms. Defendant and see.
Yeah, that'd be great. Okay. So Mitchell is here. He's back there.
Yes.
Yes. Okay. All right. So we'll hold on that. We'll see if we can get a lawyer in. Oh, so good morning, Mr. Partridge. I let Ms. Willingham, who's the prosecutor on Mr. Woods's case, sneak next door to Judge Edwards because Mr. Woods told us what we knew, which is you're in the house, but you were, of course, downstairs. So once she comes back, we'll pivot to Mr. Woods's case, as long as you can be here for a few minutes.
I think I have to shoot over to Judge Edwards as well.
Oh, okay. We'll go over to Judge Edwards and then latch on to Ms. Willingham. And do you know who she is?
I don't, but I'll make it out.
Okay. All right. Jasmine Willingham is her name.
I believe I do.
Okay. And just come back with her and then we can handle Mr. Woods's arraignment. Okay. Thank you. All right. Tyron Farmer. Don't see his lawyer either. He's on bond.
I saw that his attorney withdrew on September 28th, but I do not have contact information for him, unfortunately.
Okay. Yes, I remember now. I think I did sign that. She withdrew as in I signed the order saying you can withdraw, or she said I'd like to get out.
I think there's an order.
Yes, look at that. Okay. So Mr. Farmer would, number one, need to show up. But two, then you'd need to figure out if you represent him.
Right.
Okay. Bench warrant?
Yes, Your Honor.
Okay, you have an easy lift today. All right. Anthony Walker. Mr. Hiles, have you been in touch with opposing counsel?
I'm not even sure who opposing counsel is.
I mean, there's a name on the
I
calendar.
saw that and I looked up, I reached out to him, but I also, it looks like he might have been added because the defendant had a matter in front of Judge Cox that was resolved in August, just before this was indicted. I don't know why it was not all wrapped together. Before I asked for a bench warrant, I might follow up with asking for a bench warrant, but the plea that he entered was 15 to serve 2. I believe that would have been a commuted to time served, but I want to make sure I'm not issuing a bench warrant for someone that's in DOC custody.
Okay. Then what I'll do is say bench warrant ? And we'll rely on you to get in touch with Ms. Nelson. If he's in custody, he has not willfully missed court.
Right.
Okay.
Otherwise, I will send Ms. Nelson a bench warrant.
Great. If he is in custody, then we'll just do a production order and get him here. Because if it wasn't commuted to time served, he ought to be there for a little bit and we can bring him here. He's got a big old bond on this one. Okay.
Your Honor, may I be excused to go to Judge Emerson?
Yeah, what do you have there?
I will be with Miss Olivier.
Is that going forward?
I think so.
Okay, she was saying witness problems and I was counseling Emerson to say, what witness problems?
Well, I mean, I can tell you, losing a day, we had worked with Judge McAfee to, we're like, we can do this case in this week, but we have to get somebody in, 2 witnesses in by Friday.
Yeah.
And juggling their schedules.
Got it. But the trial can split. We have Judge Emerson for 2 weeks. So if it spills over into next week, how does that Well, you guys will work it out with Judge Emerson.
I mean, if it didn't go the first week, we'd already arranged with Judge McPhee to get on the 30th with whoever was.
Oh, whoever remained in it.
Yeah, but
Okay.
if we can knock it out, I'd rather knock it out today.
Yes.
On to the next.
Okay, great. Yes, please look up Mr. Walker's situation and enjoy Judge Emerson.
All right. Thank you, Your Honor.
Sure. All right, Ms. Combs was transferred. Quentin Oliver, this is a plea. And we have Mr. Wright. Do we have?
I don't think it's going to be.
Oh,
Your Honor, good morning.
hey, what's going on, Mr. Wright?
Hanging in there, Judge. Mr. Oliver, we've been waiting to be able to tender a plea to Your Honor's case once he's sentenced in federal court. Unfortunately,
Okay.
federal sentencing got bumped to November 9th.
Okay, so the way you want to structure it, whatever the state's offering, your client's fine with. He just wants that to be after his federal sentence, so that he knows where he'll be serving his time.
Well, correct. Plus, in the federal world, they'll use this one against him if it precedes
Right.
the sentence. So for that reason, we're just timing is the issue, Judge.
Okay. All right, I'm just getting an email here. Okay, all right, so is he being sentenced in the Northern District of Georgia, or where is he?
Yes, Judge, it is actually set for November 9th. And
Okay.
it is before Judge. Well, I had it right in front of me. It is in the Northern District before, and I sent the docket to Your Honor. Ooh. Got the case number, just not the judge. But I got the case number if the court wants that, and
That's okay, I just, if you're pretty sure it's November 9th, I know you don't control the schedule, it could get bumped, but if it's November 9th, then we just need to figure out a way to get Mr. Oliver on a screen after November 9th.
yes, Judge, I'm looking at it now, November 9th at 2:00 before Judge Thrash.
Okay. All right, so I'll work with Ms. Nelson and your schedule, and we'll get this back on after November 9th.
Yes, Judge.
All right, thank you.
All right, thank you, Judge.
Going back to position number 6.
Give me 1 second. Just have to send something to Judge Emerson. Okay. Anthony Mitchell, yes.
He is in,
Oh, 1D, because that is where Judge Whitaker is this week for 2 weeks.
So she's gonna file a waiver of arraignment on Mr. Mitchell's.
But it is, she will file an entry?
Yes. So
Okay. Thank you. Can we bring Mr. Mitchell to the door, please? Oh, because Dennis Francis is in trial. Maybe they're just right there. It's great. Maybe they have the little law firm. I wonder if they're jointly representing some. Yeah. Ms. Feely, what's your understanding of how did your office, or Mr. Lyle is a Metro defender, so it was clear from first appearance that this wasn't your office's case?
I think that's supposed to be how it works, yes.
Because I represent Shannon.
Right.
But yeah,
Right. Okay, let me talk with Mr. Mitchell. Hey, Mr. Mitchell. I'm all right. I'm Judge McBurney. Your two cases have been assigned to me. You've got an armed robbery case where you've got a co-defendant named Shannon Bowe, and then you've got another armed robbery case with no co-defendant. Your lawyer, who's been appointed to represent you, is in trial right now. And we just contacted her. She's down on the first floor. I don't think it's a murder trial. It doesn't matter. She's in trial. She's going to file an entry of appearance for you and waive arraignment, which simply means plead not guilty on your behalf, so that she can start to get all the discovery in your two cases and then connect with you to go over that discovery. I didn't want you to wonder why you were brought over. You were brought over to have this conversation. We just thought your lawyer could be here. We didn't know she was in trial. But she's otherwise occupied, but was gracious enough to shoot an email to my staff to say, "Oh, I got it. I'll file an entry on behalf of Mr. Mitchell, and we'll move it forward." So I will see you next, either because you and Ms. Cabrera is her name. You guys want to argue about bond with me? That's great. Argue's the wrong word, but make a bond motion. Or because Ms. Cabrera has looked at the discovery and has concluded that there's something that she should try to suppress. And I'm making this up, but you gave a statement to the police, but they didn't read you your Miranda rights or something like that. And she won't know that, and you won't know that. Well, you know who you talk to, but she won't know until she gets all that discovery, reads it over, and talks about it with you. So that's sort of the next steps, okay? Any questions? All right, and normally we'd bring you out here and sit you down, but since she's not here, I just figured I'd lay that on you so you weren't wondering why'd you drag me here, okay? Any questions?
No, I just want to know, is it programs? You take programs?
As in like to resolve the case, or programs while you are in jail? That's a great question for your lawyer. Your charges are pretty serious, so that doesn't mean that what happened was really serious. On paper, it's serious, not really a program type case, but maybe when your lawyer starts talking with the prosecutor, everyone will realize this is not what it looks like on paper, and we need to get Mr. Mitchell plugged into a program. So I'm not saying no, but as I look at these charges, I'm saying that would be a maybe. Okay? So you'll meet with your lawyer and you guys will start moving forward.
Okay, thank you.
Thank you. You too. Thank you for that update, Ms. Nelson. So, Ms. Willingham, Mr. Partridge.
And I didn't see him, Judge. I was standing out. I wasn't in the courtroom. I was right outside.
Okay.
And I didn't see him.
He said he didn't know you. I didn't want to describe you because you'd be like, how would you describe me like that? So I was just like, hey, just that Jasmine Willingham is her name. He's like, but he claims he had to go to Judge Edwards's courtroom. And so I told him that's where you were. I said, don't come back without her.
Okay, I'm gonna go back. Did you see me? Okay.
He's not in Judge Edwards's. How can you tell?
The first time you was, but I didn't see her.
Okay. Are you able to text your lawyer? Yeah, tell him, get over here.
And I will sit outside the courtroom, like right in the middle. So
Okay.
I know what he looks like.
You know what he looks like? He's wearing a dapper blue suit today.
Okay.
Don't let him by. Okay, thanks. Sir, you are in the way back. I didn't call your, are you here for someone else, or do you think you have a case? Okay, great. Welcome to stay. I see three things left on this morning's calendar other than the James George plea. I don't know what's going on with that. Mr. Woods, but we got to get his lawyer here. Ms. Turner, and you need to talk with her, so you should do that. And then we've got Mr. Betha. I don't see Ms. Sellers here.
Well, Judge, if the court will allow, I was going to ask if he could hold his case into the afternoon calendar. Ms. Ross is actually at Viewpoint this morning.
Okay.
Talking about his case. So.
Okay, great. I don't have a problem with that. He's here. I don't know if he's someone that's complicated for you to keep up here. Everything's good today? Good. Okay. So.
Your Honor, on James George.
Yeah.
Mr. Richardson filed a conflict for that. He is actually in trial in DeKalb County before Judge Polk. So he sent me an email this morning.
Okay. Would have been nice of him to tell Ms. Nelson, but I'm glad he told you. And I appreciate you sharing that. Dang. Okay. So we'll need to reset that. That would explain why Mr. George is not here, I guess, is that Mr. Richardson told his client, I can't be here, so you don't need to be here. But it sounds like it's a time served resolution. Okay.
Yes,
Got it. Phooey. Okay. Are there any other ones from this afternoon that we can do now? I don't know.
Yeah, we only brought the ones up for the morning.
Okay, but what we might do just to is take let's see if there's something on the final plea calendar that we could do this morning, and then we can take a break and you guys can flip-flop them. But I just assume we got time right now while we're waiting on Mr. Partridge. Let's see, we're not going to be able to do number 3 because Mr. Francis is in trial. We need a major case prosecutor for 4. Again, Mr. Francis, Ed Adams. Oh, what about Mr. Butler? Assuming Ms. Feely comes back in, we should be able to do that. And then Mr. Walls. So why don't we try to do those 2, Walls and Butler, once Ms. Feely comes back in. I mean, we won't do it the moment she comes in because you need to flip folks around, but are they both in custody?
Yes.
Butler and Walls?
Yes.
Okay, good.
And Your Honor, I know that for the Walls case, the victim's intend to appear in person for the 1 o'clock, so I would need to contact them if we're gonna have that earlier.
Okay. Is it something that you think is working out? Because if it is Mr. Wall saying no thank you to whatever the offer is, then I'll encourage you to see if they don't mind zooming in for him to say no. If it's a full-blown resolution, I don't want to do it without them here.
I've got no response from the defense.
Okay, well, we'll find out what it is. All right.
Excuse me, Your Honor.
Yes.
Yes, this is James George. I'm just letting you know that I'm here.
Oh, you are here, Mr. George. How you doing?
I'm doing all right. How about yourself?
I'm okay. So were you able to hear what we were saying about your case?
Yes, sir.
Okay, so you're YC Barron. Got it. So Mr. Richardson is stuck in trial in front of a judge in DeKalb County. So even though we were hopeful we could resolve this today, we're going to have to defer it to another day. We'll let Mr. Richardson know that you showed up. Did you get something in the mail telling you that this was happening today, or just it was special?
Yes, sir. Yes, sir. I received something in the mail.
Oh, okay. Well, we'll continue to work through Mr. Richardson. Given that this is ready to resolve, if we learn, I'm making this up, that next Tuesday he's free, we go, hey, let's do it on Tuesday. So it may be that you get a call or an email from him rather than something in the mail from the court, just so we can jump on this one, okay?
Okay. Yes, because I did talk to him and he let me know that he might not be here today. He has a matter.
Yeah, well, I guess we should why don't you stay on for 1 second? And we're going to reach out to that judge to make sure he really does have that matter. Because if he doesn't, then he could appear just like you're appearing on a screen, and we could take care of this one, okay?
Okay.
So I'm not going to, now that I know who YC Barron is, you can go back to video off and mute. And I promise not to forget you if you'll just stay on right now. We're going to try to check on Mr. Richardson's availability, okay?
Okay, thank you, sir.
Thanks for speaking up. All right, we finally have all the players here to do Mr. Woods's plea and arraignment. Good morning, Mr. Partridge.
Morning, Judge.
That's Ms. Willingham.
I'm familiar, Judge.
Okay.
I had a complete lapse of memory.
That's okay.
We've worked together on a few occasions.
Good. Mr. Partridge, Mr. Woods's case is on for plea and arraignment. Have you filed an entry in the case?
Judge, I had to refile it this morning, so I'm not sure if it's accepted, but I'll make sure that it's done today. For sure.
Okay, great. So you'll become official. Right now, doesn't list any lawyer, but you'll take care of that. Are you going to be waiving arraignment for Mr. Woods?
Yes, Your Honor, we'll be waiving arraignment and entering a not guilty plea for the purposes of arraignment today. I do know that this court typically does a scheduling order, so we'll abide by those rules as it relates to that.
Right, as best you can. If you'll fill out, there's a waiver of arraignment form there. So if you'll fill that out before you leave, Ms. Willingham will start sending discovery your way. And there will be a scheduling order, and it's going to have kind of standard deadlines. And you'll just need to work with Ms. Nelson to help us work around your schedule. As you may suddenly be, well, it already is sort of 5 days a week, but eventually it may really be, 9 to 5 trial time. And Mr. Woods, I trust you understand Mr. Partridge has a significant other commitment with his other trial. And he believes he's got the bandwidth to represent you as well. But we may have trouble scheduling things in your case because Mr. Partridge is stuck in trial elsewhere. And that may just slow some things down. But as long as you're going in eyes wide open, knowing your lawyer has that other commitment, then I'm all right with that. I just don't want you to get frustrated and say, Judge, this case is moving too slowly, assuming the state is doing what it needs to do to move the case along. Okay? And that other judge, Judge Glanville, has been pretty good about giving these lawyers a day off here or there, and then they're scrambling to deal with their other stuff. And we'll try to pile things into those days off that the judge gives Mr. Partridge. And this may be a case, I don't mean to overcomplicate it. It may be one where Mr. Partridge and Ms. Willingham talk and it's very, very resolvable, but it may not. And if it's not, that could stretch it out a bit because of Mr. Partridge's commitment. Okay. Ms. Willingham, anything you want to share concerning Mr. Woods' case? Okay. You're not aware of anything funky in discovery?
No.
Okay, great. All right. So Mr. Partridge, if you'll leave that with Deputy Gordon, then we'll get it filed and we'll get that scheduling order out. And then as best you can, keep us posted with the ebb and flow of what else you're doing.
Will do,
Okay.
There might be a few changes with the trial as well, but I'll communicate that to the court as they happen.
What would changes mean?
Essentially, Your Honor, I had my father has a broken neck and is on life support now.
Oh my gosh, I'm sorry.
No worries, judges.
Well, big worries.
He's doing better.
Good.
I've spoken to Judge Glanville. I might have to take some time off, which may sever me on the days downstairs.
Got it.
So it'll free me up.
Sure. To do other things when you've got time for the other things. Okay. Well, I'm real sorry about your dad. Glad to hear it's going better. So sad that after investing 10 months of your life, you might get severed. Huh. But then it may almost be size where he could go back to his courtroom and not have to be, we're getting down to almost one hand worth of defendants. Okay. All right. Well, best of luck for your dad.
Thank you, Judge.
Sure. Mr. Woods, when Mr. Partridge goes, you're free to go. All right. You just want to make sure you're on bond. Let's just make sure there's no hiccup. You've been on bond for over a year now, which is a good sign, especially in terms of working this out. You are supposed to stay away from an apartment on Roswell Road and have no contact with Ms. Summers. Is that something you're able to maintain?
Besides me not seeing my daughter, that's the only thing I've been trying to figure out, like that end of it, but other than that, no contact at all.
You and Ms. Summers have a kid together. Okay, so I would talk with Mr. Partridge about that because he can talk with the prosecutor, and it may be that we can modify your bond so that there is a way for you to contact Ms. Summers solely for the purposes of, hey, let's meet with a third party there. Maybe it's Ms. Summers' mom or something, so that you can hand the daughter off and I can be with the daughter for them.
I've reached out to the mom as far as for my daughter, but the mom was like in contact.
Yeah, I understand. And she's probably not wanting to get in the middle either, but your lawyer is a neutral here. And so he can talk with the prosecutor and maybe there is a way. We try not with these stayaways to impact parental relationships, assuming none of the allegations involve your daughter. And usually the case is it's the parents who got into it. But talk with Mr. Partridge and there may be something we can do about that. But otherwise, that bond is still in effect. It may seem like something from long, long ago, but no contact with Ms. Summers, or is it Bree? Is that your daughter?
No, my daughter name is Riley.
Okay, it's not written well in the order. But either way, just make sure you keep doing that stuff. Okay. All right. And are you still at Ewell Park Drive in Lawrenceville? Okay, good. So you'll get stuff in the mail, although your lawyer will be letting you know when you need to come to court next. All right. Thank you.
Thank you so much, y'all.
You bet.
Judge, that concludes my business. Have the excuse.
Yes, sir.
Thank you.
All right, Ms. Feely, what are we doing with Ms. Turner's case?
I just filed a waiver of arraignment, Your Honor, and I think I have everything I need from her. Her address is still up to date.
Great. Thank you for meeting with her. Ms. Turner, Ms. Feely may have already told you this, but what's going to happen next is that Ms. Clark, who's the prosecutor on your case, is going to get the evidence that the state has to Ms. Feely, so the two of you can look at it. And then Ms. Feely will start talking with Ms. Clark about, is there a way to work this case out? Does it need to go to trial or what? You'll get notice at, if you're still at that Paradise Court address, things will go in the mail there. But also make sure Ms. Feely always has your best cell phone number, email address, so she can track you down. Okay? And then last, I need to talk to you about bond as well. Because your bond is really old. So you were supposed to stay away from a Tamika Adams. Is that something you're still able to do? Yeah, well, I like the extra 20%. That's good. And then there's this requirement that you stay out of Fulton County except for work, medical, court appearances. And maybe in June of 2021, that seemed pretty necessary. But you should talk with Ms. Feely, and that may be a condition that I ought to remove. Obviously, I need to get input from the prosecutor, and there may be reasons not to remove it. But back in June, that may have made a lot of sense. 2 years later, maybe not so much, especially if that is impeding your ability to lead a productive but safe life. So I encourage you to talk to Ms. Feely about that, and she may file a motion, and it may be that Ms. Clark, the prosecutor, says, sure, 2 years have passed. Ms. Adams has no concerns, and so we can modify that bond. Okay? All right. Anything else, Ms. Feely?
Yeah.
All right. So we'll see you, Ms. Turner, sometime soon. All right.
Judge, and the update on Mr. Richardson is that he is starting openings.
Got it. Thank you. Mr. George, YC Barron, you still there?
Yes, sir.
Excellent. We just got confirmation that Mr. Richardson is in fact in trial. They're going to give opening statements this morning, which means they picked a jury yesterday. So I'm going to let you go. We'll work with Mr. Richardson's oh so busy schedule to figure out when we can get him here and get you here. Virtual is fine, like you did today. In person is also okay. But just stay close to your lines of communication with Mr. Richardson, okay?
Yes, sir.
All right. Thanks for your time.
All right.
Attorney Wood.
I have an add-on under iPhone 2.
Okay.
Baxter Ross, he's from the 1027 trial calendar.
Do you have a case number?
Yes, it's 22 SC 184531, as well as 22 SC 183543.
All right. Let me just pull them up here. Gosh, it got ready for trial. There's like request to charge and everything filed. And he is on a trial calendar coming up.
Yes, he's on the October 27th calendar.
He is. Hey, iPhone 2, can you, there you are. There he is. Okay. And what are we doing with Mr. Ross today?
Well, Judge, if I may, I need to step out. Ms. Willingham and I have been working really hard on these cases. I think there was a little bit of a misunderstanding in our last round before I headed it. So I just need to talk to Mr. Ross to see if we're gonna move forward with you today.
Okay, so you'd like to talk to him,
Yes.
so he should drop off?
Yes.
All right, so Mr. Ross, can you hear me?
Yes, sir.
Great. Ms. Wood's going to give you a call in just a second to talk a little bit more about your cases, and then I'm hopeful we can work them out. But if not, I will see you on October 27th when we call the trial calendar. You'll need to be here in person, not virtual, for the call of the calendar. But it may be that the two sides are close enough that we can sort your two cases out today, which I'm happy to do this morning. So if you don't mind dropping off the Zoom, Ms. Wood will give you a call. You still have the same number she has?
Yes, sir.
Okay, she'll give you a call and we'll figure out what the deal is, okay?
All right, thank you.
Thank you. Ms. Feely, we were wondering, in an effort to be efficient, if we could do the final plea. We'll need to take a break to move people up and down on Mr. Butler. And then maybe Mr. Walls, although there were some victim, it must be on position 11, not position 10. There were some victim folks who wanted to be here. If it's going to be a plea, we could see if they could Zoom in this morning, but we've got this extra time. I thought we would try to knock out some of the final plea stuff.
Sure, if I can speak with them in the back. I think
Great. So I'll go away and we will get Walls and Butler up.
Yeah, Walls.
And thank you. Mr. Partridge, you didn't sign it?
I'll scan it.
Okay, thanks, dummy. Ms. Clark, on, since we've got a public defender in here, I'm okay talking about it. On the Mr. Cherry situation, I kind of blindsided you with that one because we forgot about the deadline for this next Judge Emerson calendar, and he's a perfect fit for that. And I don't know, that case is inactive on your docket. So you have no reason to know anything about Mr. Cherry or his 3 cases. And you very gamely said, hey, we'll do this one. I'll put that one in as our submission to the Emerson calendar. My request to you is to poke around in all 3. One of them has some super serious charges. That doesn't mean that's the one you would need to try first. You get to pick up. You need to sign this document, my friend. It's all right. You can come all the way up to Ms. Nelson. So we'll put as our submission Edward Cherry and the 21 SC, whichever one you listed, and that may be the one you want to stick with. But if you could, over the next few days, just look through the files and confirm, yep, that's the one. I told you what I meant, Judge. Or and looking at it more, this is the one we want to try because it looks real good for the state. And if he's convicted, he's going to get 1 million years to serve, and we'll just deal with those other ones.
Okay.
He has, just so you have the full backstory, he has an open murder case in Clayton County. He's been indicted, and they won't take him because they had an issue where they accidentally released one of our loan outs who had some pretty serious charges. And so they will not take him until it's murder trial time. He keeps picking up new charges in our jail. And so folks at the jail have said, could you get him to Clayton? And Clayton, I've said, Clayton, will you come? No, why would we come get him? He's your problem until our trial. And so he's been in the jail for 3-4 years almost. And Ms. Wood understandably has said, could we just then try one of his cases? So that's why it suddenly come back to life. And so again, if you just look over the 3 and just either confirm, yep, the one I told you, or I want to switch it up. We just need to get on that Emerson calendar so we've got a spot for him. Okay. All right. So I'm going to step off the bench briefly so you guys can swap out those folks. I'll come back out either because we're handling well, we have to figure out what we're doing, Mr. Ross, and then also because we could do those final pleas. Anything else? No? Okay. Oh, is he gonna do the swab now?
Yeah, that's what we're.
Collecting evidence in court. That's kind of exciting. Glad it's not drawing blood. Way back when I was a little ADA, we had to do one of those out at the jail. And the guy, we had a search warrant. The guy like, I'm not letting you do it. Not letting you do it. Had to bring in all these orderlies, hold him down, pull his mouth open. I'm like, oh, come on. Why did I come along for this?
I first thought it was taking pictures of the body with vaccines and stuff.
Yeah. Yeah. And like, you don't have, it's a search warrant. It's not a, you get to say yes or no, my friend. You're not getting my saliva.
We were originally gonna, send him over to the jail. However, it worked out that we were already on capital.
Look at that. Okay. I was a little sheepish. I'm like, yeah, you should already have done that. I'm like, why? Save the trip.
Yes.
That's why I was like, I recognize that giant guy back there. All right. So let me know either when we're ready on Ross, or we've brought up those two, and we'll do those two final pleas. Thanks. Uh-oh.
Nelson.
Hi, how are you?
Good, Angel.
I'm doing okay.
Hi.
Hello. Finally I get to meet you in person.
Yes, ma'am.
I'm Deidre.
Christina.
Nice to meet
Nice to
you.
meet you.
Welcome to our clinic.
Yes, ma'am. Thank you.
If there's anything you need, your emails are fine as long as you email me. That's great. That's my keeping me without after and ask about the process.
Yeah, if you have some time, just talk to me about, those practices and what works.
Yeah, you don't seem like you're doing that. That works for me. But yes, anytime, I'm usually, I work remotely, but I'm Tuesdays and Fridays, and that's when I try out a little bit more.
Okay.
Yeah, today's fine. Yeah.
I wanted to, and I'm gonna send you an email. I saw that, Miss, Leo, I think I mispronounced her name, sent a conflict, and we're supposed to have the motions here on the 20th.
Yeah, I looked at that conflict, and the conflict was the 18th, and then the 20th were her first case listed. So I'm not taking it as we're gonna reset it or anything.
Okay.
Because I think the cases that she listed is sometimes they just
Okay.
so as far as I know, the motions.
Okay, all right. I just wanted to know because I subpoenaed my officers.
Right.
Okay. Thank you.
Well, Miss Nelson.
Hey, how are you?
Hi, how are you?
Okay.
Looks like it's not happening.
On George.
On Ross.
Ross. Is that his name?
Yeah, Baxter Ross.
Baxter Ross.
He was on having 2 cases, so.
Well,
We'll let you know if we can get them.
I didn't like, cause I was out yesterday, but I don't know if anybody really confirmed.
We did.
That's why
Yeah.
I didn't put it on the calendar.
That's totally fine.
We
We
did,
didn't, no, that was fine, we did it, and cause yesterday I reached out to Lacey and I was like, we should clarify one thing before we do that, you know what I'm saying?
Yeah, I didn't think, I was like, it wasn't the, I usually have a solid.
Yes.
But
We weren't solid today.
Yes,
so totally
fine. So,
Okay.
that's okay. He wasn't, he's not in custody.
He's out of bond.
It's feeling.
Morning. Thank you.
Holiday.
Yeah, I was.
Thank you. You have a holiday?
I went to the beach.
Would you mind?
Yes.
Thank
Thank you.
Would you mind saying that you?
Yes, sir.
You remember me?
I thought about that, where I remember you from, when I was standing there. He's staying out of trouble, I'll say that. He's going through some stuff job-wise, but he's working through it, but he's staying out of trouble though.
Okay.
That's all I can
Well,
ask.
tell him I'm counting on him.
I'm gonna let him know that you asked him to. I'm about to text him right now. Thank you so much. Good to see you.
Good to see you too.
Ms. Willingham, we'll talk.
Yes,
All right, y'all be good. Have a great day.
you too.
You know, if Adam's on trial,
He is, they are closing today.
who's Adams? Is that what it's, okay. That's what I thought. So who's? I don't think we have anything to say.
For this afternoon,
Yeah.
we do have some things on there. Me and ADA Clark talked about it. We are going to figure out who's supposed to come for Mr. Abate. I mean, they may be done closing by then, because I think they were supposed to close this morning, but I don't know what their schedule is like.
I don't know if Dennis Francis is actually not going to be present.
Okay,
So I don't.
so he may not have
I
to,
mean, I'm just assuming, or judges assuming, because Euphemia's on trial. but
yeah,
I don't remember getting anything from Mr. Francis.
okay.
Oh, yeah. Oh. I'm sorry. Oh, yeah. Yeah, I talked, I let him know that as well. I let him know all that as well, told him that we would help him out, housing and all that stuff. So. Yeah, this is not. 100%. What do you got?
Well, setting someone up for success.
Oh my goodness.
Okay.
You know what this is? LOL.
Well, that's what happened while you were away. I was doing prelims.
Do you know anything about this integrated treatment?
What is this? This is for one case. Yeah. No, that's a thing. Hey. Yes. What's your first name? Okay, hold on. Miss Correa? Okay. Are you Mr. Samuel Lopez? Are you Mr. Lopez? Oh, I'm sorry. I can't see. Okay, I don't see you on this calendar. I'll look you up the original schedule.
Yes.
Okay. What's your date of birth? Oh, they here take a seat. Yeah, so it is this is one here, I don't know where I think it's down here. He's Ivory's former client, but the thing says 1D, but he used a Whitaker 1D, so I'm not just. We walked all the way down.
Yes. No. Yes, two, right? Okay.
And both of these are walls.
Okay. I don't think they're gonna do the same, supposed to this afternoon. Judge said that he's gonna confer with them because they may just reject the offers. You got my email about canceling the bench one on the Tiffany girl?
Yeah, but I'm out to do the other.
Yeah, but there are some other ones I'm gonna send you. I'll just give them to you like after.
Okay.
Mhm.
So you want me to go ahead and do the first one now? I can go ahead and do that one.
Yes, mhm.
Okay, you have everything else you need?
Yes,
All right, just email me if you need something else.
okay.
I'm about to start pulling those files for.
Yes, sir, thank you.
Yes, ma'am.
Mr. James,
Yes, ma'am.
some of the files,
I already have.
no. Check, make sure in this bucket, in my bucket, that I don't have, because you can take those with you. I think those are for afternoon.
Johnson. Hinton.
Those are for afternoon.
I'll put these, I'll make a stack.
All right,
Are you gonna come back between now and then?
yeah, I am.
Okay.
Okay.
I think she needs to speak to somebody.
She back there? Is it a problem?
Yeah, he ain't a problem, he a problem.
I don't know where she went. You can text her.
That's me. Need to talk to him, so you got downstairs.
Yeah. Oh, yeah? Is he, he's back there and not on the other side? Oh, because my guy's on the other side.
Yeah, so it's.
Oh, no. Oh, my gosh. Okay, I'll text her right now. I'm not sure where she went. What courtroom are you usually in?
5C. Jersey.
Oh, yeah? Oh, were you on there?
That's my son, so.
I covered in there the other day. Were you in there? I was on Zoom though.
Yeah, I was in there.
Oh, yeah?
Yeah, we were supposed to have a trial, but
Oh, yeah? Who was, do you know what attorney it was?
I forgot his name.
Was it from my office? Clark?
Okay.
Is that him?
Yeah.
I'm texting her right now.
I think he wanted that second one, he wanted to eat somebody else's food, so I can't do that.
Is that him?
He's done that too.
I mean, I'm happy to talk to him. I don't know. Is this?
She really wanted to talk to us, that's what I'm trying to.
Yeah. I mean, I'm doubtful it's gonna resolve today, but yeah, I don't know that for a fact. Okay.
Hello. Or YC Barron is still on. Mr. George, you're free to go. You're welcome to stay on, but we will not see Mr. Richardson today. Is Miss Feely back with her clients right now?
We're looking for a judge.
We're looking for her. Okay. I was asked to get Mr. Butler out here soon.
Yes.
Well, look at that.
Be a little excited this morning too, though. A little excited.
Mr. Farmer? All right.
Your Honor, this is Mr. George's mother,
Hey, Mr. George's mother.
Major Barron with DeKalb County Police. I'm just one of your courtroom junkies, that's all.
Hey, well, you're welcome to stay on. I just wanted to make sure poor Mr. George wasn't thinking like, is it really okay to go? Because it really is.
He's left, he went to work already. Yes, sir. I just been following you on YouTube, so.
Wow, now you got a front row seat. All right,
Yes,
well.
sir. Thank you.
Keep it up. Thank you. You put out an all points bullet. Oh, hey, we're gonna talk about Mr. Ross.
Oh, yes, Judge. Unfortunately, that is not going to resolve today. Ms. Willingham and I are going to continue working on it hopefully we'll get something before the 27th. I don't know if he made it back on.
He doesn't need to
Okay.
be. I mean, you've got a way to reach him and he was add-on anyway. So as always, and this is food for you as well, Ms. Clark, if you guys sort something out in advance of the trial calendar, let's try to take that plea before the trial calendar because those days are zoo-like. And Deputy Gordon always appreciates it if we can shrink the list down. But sometimes it takes that last minute push. You spoke with Mr. Farmer?
I did.
Great. He qualifies?
He does.
Great. Mr. Farmer, come on up, please.
And this would be Miss Feely's, but I'll take it, Judge.
Great, I appreciate it. And Miss Feely's not back there? Okay. Butler, that we're hearing?
She is on her way.
Okay, good. Come on up and stand with Ms. Wood, please. All right, you are Mr. Farmer. You had Ms. Mormon as your lawyer, but she withdrew for whatever reason. I allowed her to withdraw. You've spoken with the public defender and you qualify for their excellent representation. So Ms. Wood's partner, Ms. Feely, will be the lawyer who's working with you going forward. Today's plea and arraignment. So it's an opportunity for you to enter a plea of not guilty and move the case along, assuming that's what you want to do. And I'll talk a little bit about that. Is Mr. Farmer waiving arraignment?
Yes, Judge.
Okay, so Ms. Wood will fill out the waiver of arraignment form. That's just a formal entry of a plea of not guilty. That'll trigger a scheduling order and an obligation by the state. Ms. Clark's the prosecutor. She's seated right over there. She will be getting all the discovery in your case to Ms. Feely, who will then sit down with you and go over that to see, are there motions that need to be filed? Is there something that ought to be suppressed? Or is this a case that really ought to be worked out sooner rather than later? But that's a private conversation for you and Ms. Feely to have. And as long as you've left Ms. Wood with good cell number and a good email address, then Ms. Feely will reach out to you once she gets that discovery. She'll want to sit down and actually, there she is. That's Ms. Feely. Hey, Ms. Feely. This is Mr. Farmer, new client of yours. He's waiving arraignment, and once you get discovery, I'm sure he's going to want to sit down with you to talk about the case. It's position 9 on the calendar. Let me check one thing for you. So you got a bond a little over a year ago, Mr. Farmer, and that bond requires you to stay away from Sidney Marcus Boulevard. Actually, it says to stay out of Fulton County, except for coming to court and seeing your lawyer. You've got an ankle monitor now?
Yes, sir.
So you've had an ankle monitor for over a year. All right. I encourage you, as one of your first conversations with Ms. Feely, to talk to her about whether we ought to modify your bond conditions, get the ankle monitor off. And I don't know if you need to be in Fulton County. Let me see what address we've got for you. Hopefully you don't live in Fulton County. Because I live in New York. Yeah, Jamaica, New York. Holy smokes. You came all the way down here for this. Okay. Probably another reason to get the ankle monitor off since you don't even live in Georgia. So 158th Street is a good address for you?
Yeah, 134-58-158.
Yeah, what does that mean? Is that an apartment?
No, that's a private house, but the address is a little different.
Funky address. Okay, Jamaica, New York. Good. So you get stuff in the mail. More importantly, Ms. Feely will be calling you or emailing you. We can handle many things virtually, so you don't have to come all the way down here. You may want to because you got friends or family, but if things are low key, I don't require you to be here in person. If you're pleading guilty and you go to prison for 100 years, you need to be here in person. But if it's not something like that, then talk with Ms. Feely about having a virtual appearance. But it sounds like staying out of Fulton County is easy. We'll leave that condition in place. But I encourage you to talk with Ms. Feely about getting the ankle monitor off. Wrinkle, if you're getting it off, you need to be here to get it off. So I don't know if you're going to be here for a few days, and then Ms. Feely might want to talk with the prosecutor about me modifying the bond in the next few days so you can get it off while you're here. Otherwise, you'd need to come back down to get it off. Okay. Maybe worth it if it's a hassle. I never won one before, but You've had it for a while. Ms. Wood or Ms. Feely, anything else in connection with Mr. Farmer's case?
No, Your Honor, thank you.
All right, so Ms. Clark, you will get discovery to Ms. Feely once that scheduling order hits?
Yes, Your Honor.
Great, all right, thank you. So Ms. Feely, do you need to talk with Mr. Farmer or Ms. Woods covered it? Okay, Mr. Farmer, you are free to go. Again, if you're gonna be in the Atlanta area for a few days, you may wanna talk with the lawyer about the whole ankle monitor thing. But if you gotta get back to New York, do your thing. Sure. All right.
You go back. You go back.
Have you not met with Butler or?
They weren't up yet. It
They
seems
weren't
like
up.
Butler is.
Yeah, he's back.
Okay.
He's a little excited, but.
Yeah.
I did not know that.
Well,
It may be we shouldn't talk with Mr. Butler today, and I'll let you sort that out. If you'll talk with those two, we'll try to take care of them. All right, so Ms. Clark, if we recap, we've got a bench warrant on position 1. Bench warrant on position 4. And 5. That's all I got. Did you have other bench warrants? We're not sure about number 10, but that's not your case anyway, and Mr. Hiles asked to hold off on that.
That's all I have, Your Honor.
Okay. Now, you had mentioned bond forfeiture as well. I'm all for doing bond forfeitures. That's a process that your office takes the lead on. So if you are a bond forfeiture lawyer, we'll do them and we'll have calendars for them. But much of the procedural burden falls on the DA's office in terms of making sure it's timed right and getting notice and all that. And I'm happy to support it 100%. Your predecessors in here would always say, bench warrant and bond forfeiture, and then there'd never ever be any bond forfeiture paperwork.
Okay.
Up to you. Hopefully someday all the judges will say, come on, we need to forfeit bonds if people don't show up. But with the judges not leaning on the prosecutors, I don't fault the prosecutors for not doing it. But there are a handful of judges where 100% they'd be like, wait, bench warrant, you better go do that bond forfeiture paperwork.
Okay.
So you can just let me and Ms. Nelson know if that's what you're doing.
Yes, Your Honor.
Oh, yeah, hold on, let me, okay, set this up.
Does Judge Leffridge have inmates too, or anything I hear is our people?
She's on trial.
Oh, from that time of picking with like 5 million jurors and all that. And that strange jury selection process, right? Okay.
It's just Mr. Butler.
So this guy who didn't show up today, because it looks like he is in DOC custody, was supposedly in YSL. Anthony Walker is his name, and he was here on gang stuff plus trafficking and heroin, but it's from July of 2021. And so the first count says in July of 2021, he unlawfully, while associated with criminal street gang, Young Slime Life, participated in gang activity, blah, blah, blah. He just resolved some case, I guess it sounds like in front of Judge Cox, and went to DOC.
He wasn't a part of the 28 defendant suite.
Nope. But it just seems like anything that has YSL in it should go, or like, hey, man, you're dealing with it, take the little pieces too.
28 to 7, 6.
Yeah, you heard that guy? If his guy breaks, imagine.
But they
Yeah, I know. The trial is longer than a lot of the sentences. But the main guy is still in it.
Yeah.
Okay.
They offered him like 8 years.
28.
He said no.
Nope. I just did the motion for new trial on, he was in the 59 Brims, Josiah Lee. Yeah, and was I didn't remember, what I remember was the pizza box, and then maybe it was an armed robbery. I mean, they beat the guy up, took some of his stuff. I forgot his testimony at trial was, I was 59 Brims, but I was a peacemaker. I did the bounce houses and had the barbecues. That was his version of events. Okay, good to know. No bounce houses when you hit. No. I've just been sitting on it for a while, and Brian Steele had sent a letter, dear Judge, I know you're busy, but we had the hearing in February. Could you rule on? Yeah, I'll rule on. So probably not the ruling you want, but up to the Court of Appeals. But it was a clean trial. There wasn't.
I remember that trial. I think that was one of the first ones.
When you were first working with us, or?
It was earlier this year? No.
No, the trial would have been last year. The motion for new trial hearing was this year. It was in February of this year.
I remember that trial.
Yeah. I mean, he's good lawyers. Mr. Steele does a good job. He doesn't have a lot to deal with. So there was all this stuff about the pizza box. And then the poor crime scene technician, like we had to go through forever. This guy has a small apartment, and what's right here? That's a television that's broken. And what's right here? And then, does this chair look overturned? Yes, the chair is overturned. So Ms. Wood, we're not waiting on any of your cases. It's both Ms. Feely's?
Correct.
Okay. We did learn, well, it's not either of your cases. Mr. Walker, number 10, is in DOC custody.
Oh, yeah, there was a guy that came in here and he was looking for that courtroom and I had no idea it existed, but we found it. Thank you.
We get a lot of, what's the JAG?
Yeah, I literally had no idea. Judge McBurney, Mr. Farmer is here until Friday, so I'm gonna file a motion to modify his bond condition. Do you think we might be able to add that somewhere so that if the court would grant it, we could get that off before he leaves town?
Why can't we just talk about it right now?
Love to do
I mean, other than making sure, was it your case, Ms. Clark, that the state has a chance to contact the victim? And the guy lives in New York, so I always want to be sensitive to victim concerns, but presumably that person hasn't had a whole lot of contact with Mr. Farmer. So I don't. In fact, I don't know if we need to have a hearing. I think you should file a motion, and then the state doesn't need to respond in writing. I'll just give Ms. Clark or the victim advocate an opportunity to contact the Nia Collier. And this isn't a super ancient case. It was July of last year that the bond was set. So maybe the contact information for Ms. Collier is still good. And if she hasn't had any contact with Mr. Farmer, hopefully the notion of taking we'll keep the stay out of Fulton County condition in place. Just we take the ankle monitor off.
Thank you, Judge.
Sure. Ms. Clark, if Mr. Walls wants to sort stuff out this morning, have you had a chance to contact any of the victim folks to see if they can dial in? Yeah. And I don't want to get him riled up. He may come out, Ms. Feely may come out and say, not a chance.
I was waiting to see if she was gonna say the offer was gonna be rejected or if it was just gonna be a reset or.
Okay, well, it wouldn't be well, I don't think Mr. Walls is the one who was having some concerns back there. So if he says no thanks, he'll still come out into court and we'll get the we'll get the offer on the record and he'll say no, thank you.
Okay, let me try to call him.
Okay. Give me 1 sec, Ms. Feely, and then we'll make a plan. Okay, Ms. Clark went outside just to check in with victims in connection with Mr. Walls's second case. But if you could just give me an overview, we've got Mr. Butler and Mr. Walls. Can we do the final pleas this morning?
We can on Walls.
Okay.
On Mr. Butler, Ms. Ross has been to see him as well as other social workers, and I think he's just decompensating at the jail.
Okay.
He was kind of like this when I saw him a couple of weeks ago, but I don't think he's thinking very clearly.
So we should take him off track because the next stop would be a trial calendar, but we can't even do final plea at this point.
Right. I think it's now starting to border on competence when
Okay.
it wasn't before. So
How should we put Mr. Butler on a inquiry calendar a little ways out? I don't know that having him stay where he is will lead to improvements, but it may regrettably lead to degradation, and then you move for another evaluation. Had he been evaluated?
not pre-indictment, no.
Okay, all right. Was this something that was at least sort of on your radar as you were interacting with him? You may not have spent a ton of time with him, but was this sort of out of the blue?
It's gotten worse.
Okay.
So yes, there were signs but not to the extent the last couple of weeks have been.
Okay. So what do you propose? That we put it on an inquiry calendar? How far out? A month out?
I think a month out would do it. And he also has an unindicted case that we kind of need to move together, hopefully.
All right. We passed the competency docket for our bench, which means it'll either start in the middle of November or January 1. And as of that date, judges have the ability, they don't have to, but they may transfer any case where there's been a finding of incompetency or there's an NGRI or someone files an insanity plea to that docket. One judge will manage that. And I assume Ms. Sellers will handle things from the state side. Ms. Walsh is fretting about who will handle it from your office's side, but most of the cases will be your office's. That will be something that more expertly and efficiently focuses on cases with competency issues. So I flag that because if Mr. Butler gets evaluated and is found not competent, I'm sending him to the competency docket. And then you could choose to stay with it. That's going to be an internal process that your office works through. But you all should know that, I remember if Mr. Dunning has already been found not competent, but cases that are in that posture, I will be actively participating in the program. Not meaning I'm the judge, it's not my job, someone else is doing that, but I'll be certainly sending cases there so that we get that focused expertise of a judge who's going to specialize in it, and certainly a prosecutor who specializes in it, whether how your office staffs it. TBD, we're going to be talking about it this Friday a little bit. But that's a new and I think welcome development to have those cases clustered with a judge who's in a position to have regular contact with DBHDD and et cetera. Okay. But for Mr. Butler, we'll reset inquiry 30 days. See number 7. Okay. As to Mr. Walls, is this something he wants to resolve today, or he wants to say no, thank you, and we move him to a trial calendar?
He wants to say no, thank you. He wanted, his wife was coming at 1. So I'm going to try to make contact real quickly with her.
It's already, I don't mind waiting until 1. Ms. Clark had the same scenario where there were victim family members or victims who wanted to be present. So it's going to be now a very short calendar because a bunch of the cases are Mr. Francis's and he's not here. So I was just, to shrink it down, I was going to say, let's do these this morning. We've taken care of Mr. Butler. I don't remember when you came in the courtroom, but Ms. Feely is concerned that Mr. Butler may not be competent. And so we're resetting for a month for an inquiry calendar, and her office will continue to explore options for Mr. Butler. So that's off the let's go to trial track for now. I don't mind just regrouping at 1, and that way folks don't have to shift around their schedules for Mr. Walls. Okay.
Mr. and Mrs. Mitchell were about to jump on.
Okay.
Okay, but I want to know.
Well, before, let's just, if you can get Mr. Walls's wife on, then we can still do Mr. Walls. I just didn't, I don't want everyone saying, Judge, you switched it up on us. Let's see if Mr. Walls's wife can get on, and then we'll do it. The Greater Solid Rock Baptist Church got on. Is that the Mitchells?
I don't think so, Your Honor.
Okay. Good morning, Ms. Jackson. How are you doing?
I'm great. How are you, Judge?
I'm well. I haven't seen you in a long time.
Yeah, they kind of have me all over the place.
That's how it is. Well, we will wrap things up pretty shortly if we can get Mr. Walls's wife on. That won't be a plea, but I'll need you and Ms. Rivers to hop back on at 1. I don't think there'll be any pleas. We've got some attorney unavailability in a few places, but I can't say for sure. So if you don't mind being, you or a colleague being back at 1, that would be great.
Yes, I am, Your Honor. I'll be there.
Okay. All right. Thank you.
Good morning, Judge.
Good morning.
Hey, this is Attorney Rowe, Judge. I just got out of a conflict. I'm here for Mr. Anthony Walker.
Great, thank you. And thank you for flagging with my staff that you had a conflict. So we knew to hold for your report. That is position 10 on our plea and arraignment calendar. The prosecutor on that case, Mr. Hiles, was here. He had to go. He's helping someone with a trial. We do have a prosecutor in the courtroom, so I'm comfortable talking about the case. Where do you think Mr. Walker is?
Judge, I just did a plea with Mr. Walker probably about 3 months ago. He should be in the state system. He may be down in Jackson.
Okay, that's what I think too. My litigation manager, Ms. Nelson, I think has found him. So he is not voluntarily or willfully missing court. He's stuck in federal custody. I mean, not federal custody, state custody. So no bench warrant for him. Will you be representing Mr. Walker for this case?
Yes, Judge. I was retained some time ago for this case. But the only thing about it, Judge, is to be frank with you, I had intended to file a motion to withdraw from the case. But I'm not sure if his family will hire me if the case is placed on another calendar by then. But if not, I was going to file a motion to withdraw.
Well, let me tell you where I think we are. Mr. Hiles, the prosecutor, was kind of confused that this didn't get resolved when everything got resolved with Judge Cox. I've looked at the indictment. It's some old stuff. It's from 21. You know, it's got the allure of saying YSL, but to me, the focus would be the heroin charge. I don't know. It may be one that's easy to work out because Mr. Walker's already serving some time, but that's a discussion for you and Mr. Walker to have. We will need to reset it. We would reset it so that Mr. Walker could appear virtually. We wouldn't drag him out of DOC custody because he's probably getting situated and whatnot. We just figure out what facility he's in, and then he would Zoom into court virtually. And I'm going to want to do that in fairly short order, especially if you're thinking you might roll off, because then he's got to find a lawyer. My guess is he doesn't have any money if he's sitting in prison. And then we can get a public defender appointed. But if you might stick with it, if it's an easy resolution, then I'd sort of like to do one more touch to see if you and Mr. Hiles could talk about it. But I don't mean to bind you in any way. If you've burnt through your retainer, I'm not trying to make you work for free.
No, Judge, I actually like that idea as well. I don't mind just trying to see if we can go ahead and work it out. I stay on it a little bit to see if we can go ahead and resolve it since he's already in custody on, I think, 3 or 5 year sentence, something like that. I think it's 5 years. But yeah, I agree with you, Judge. I would stay on it and try to speak with the prosecutor.
Then what I'll do is I'll reset it and then I'll shoot an email to you and Mr. Hiles connecting the two of you to say, hey, you guys just talk to see if this is a quick resolution. If it's a quick resolution, Mr. Rowe is going to stay on the case. And if Mr. Hiles says, no, you know, it's complicated and it's gang related and this and that, then by all means, you should roll off it. That's not the vibe I got from Mr. Hiles. He was scratching his head like you were, like, why did this not get rolled into the Judge Cox case? So I'm hopeful, but not obligating anyone, that this would be one where you two would talk. Then you get in touch with Mr. Walker. We get everyone on a screen, and it's something that's concurrent with whatever he's doing right now.
Sounds good, Judge.
Okay. Appreciate you dialing in. I'll get an email out to everyone and we'll reset this.
Okay. Thank you, Judge.
Thank you.
All right.
What did you learn, Ms. Feely, about Mr. Walls' wife being able to hop on?
She is on her way.
Oh, she's going to appear in person?
Yes.
Oh. And what is ETA?
Didn't get back to me on that yet.
Okay.
Judge McBurney, for the 27th trial calendar, it says that the jury will be picked. I just wanted to make sure I had the correct dates. So would the first day of testimony be the same day as the jury selection or the day after?
Unless you are the fastest jury selector I've ever met. Jury selection will take the 30th, that Monday, we'll pick a jury. Lately, we've been pretty efficient and maybe we've got the jury by 4:30, but then I tell you, spend a long day, go home or go work, whatever you're doing to get ready for trial. But no, the openings would be the morning of Halloween.
Okay.
Actually, so you could choose to wear a costume. That's the way that week is playing out. So the 27th, we call the calendar, hopefully take a lot of pleas. And then the 30th, pick the jury, and then start with evidence on the 31st.
Oh my God, this is good. Yes. So if well, I'll tell you when I get back.
Ophelia, you guys all settled into the new house? I know it's been a while, but is that transition over and done with, or there's still moving parts? That maybe there was nothing to move.
Parts because the real estate market is nuts right now. But
had you moved into a temporary location?
So it's just been a year. September 23rd was the anniversary, and so we used because you get a pot of money that's for like living expenses when you rebuild, and so we use that as a down payment on another house.
Right.
So we're living in East Atlanta, but they're just about done with the Kirkwood house.
Oh, meaning so you put a down payment on a house that needed work done on it, or it was an empty lot?
It was perfect. It's a little 4.2.5 because while we were rebuilding, just instead of. just
Oh,
renting
so
something.
you're going back to where you lived?
Maybe,
Maybe. So you own 2 houses now?
sort of.
Oh my gosh. Ooh, a land baron.
Yeah.
I didn't realize that.
Became a little tycoon on accident.
Yeah. Huh.
But now, Raven, yes, but if Raven gets the go ahead, from that point, I'll come back to handle him. I'll text you that.
Okay. Mr. Walls' wife said 20 minutes, but she also said Cobb County, and I don't know how consistent those two things are.
Okay. Well, that puts us in a bind. Well, why don't we do this? I don't want to he's not going to enter a plea?
Right.
Okay, so, Ms. Jackson, you are free to go. We will see you at, 1:00, please.
Thank you, Judge.
Mrs. Mitchell are on.
We're going to still do this morning. I see that the Mitchells are on. I was just trying to balance, folks. Ms. Tucson, will see you at 1:00 also, please.
Okay, no problem.
And I'm just going to go back and do some work there if the Mitchells don't mind sitting tight once Ms. Walls gets here. But I'm coming out at 11:30 if she said 20 minutes a while ago.
Not that, maybe 10 minutes ago.
Okay, but that's fine. I'm gonna come out at 11:30 if I haven't been hailed before then. And we will handle Mr. Walls's 2 final pleas. Okay, so if the Mitchells don't mind sitting, and they can also dial back in at 11:30. Just we would start earlier if Ms. Walls showed up, but you could always call them. So I'll let you manage what is most convenient for them. I don't mean to make them wait.
Okay.
All right, I'll come back out. You good with that? Okay. This afternoon, we should bring everyone else up during the lunch break, but a whole bunch of them, I'm just gonna bring them out and say your lawyer's in trial and we'll have to reset them. Maybe we can move something, but sort of a dud of a final plea calendar. We'll see. All right. Thanks, guys.
Hey, did you get my message? I'm still in regarding, I'm gonna step out. Wait. No.
You said we had 11:30, right? 11:30.
Yes, I'm sorry.
No, you're good. I had to tell them to stop doing all that yelling. I am very clear right now. She good though.
All right. I see that the Mitchells are still on and Mr. Walls's wife was able to make it.
Yes.
Great. If we could bring Mr. Walls out, excuse me, please. And Ms. Rivers, good morning. How are you?
Morning, Judge. How are you?
I'm well. We're going to need to get this on the record when we get Mr. Walls out here. Yes, Ms. Clark.
Oh, also, the other victim in the case, Mr. Ryan Henderson is on as well.
Okay, great. Actually, he can sit right there in the middle seat, please. Thank you. All right, let's get on the record in Mr. Walls's two cases. It's positions 10 and 11 on our final plea calendar, which was supposed to be this afternoon, but we had a little extra time this morning. So thank you to everyone for shifting your schedules around. It's 23 SC 187869. That's a case in which Mr. Walls is charged with possessing cocaine and a gun. And then 23 SC 187874, which has multiple counts of aggravated assault that involve allegations that Mr. Walls shot at a number of folks, to include the Mitchells, who are observing through Zoom, and Mr. Anderson, who is observing through Zoom as well. Today is the final plea date. This is the last day Mr. Walls could enter a plea of guilty to either of these cases and have the ability to withdraw that plea if the sentence that I imposed was more severe than the sentence that he asked for through Ms. Feely. So just by way of example, if Ms. Feely asked for a sentence of 10 years to serve 2 years across these two cases, and I sentenced Mr. Walls to 10 years to serve 3 years, that's more time. And Mr. Walls could say, you know what? I was willing to not go to trial and take a plea. If I got what my lawyer asked for, Judge, you gave me 3. I'm going to go back to jail and wait for my trial. After today, Mr. Walls, you can certainly enter a plea. You're free to enter a plea at any time. And I'm not suggesting you ever have to enter a plea. You also have a right to trial. But if you enter a plea after today and the sentence I impose is more severe than what Ms. Feely asked for, that's the sentence you get. You don't get a withdrawal because you're dissatisfied about the sentence. So that's the main thing that changes from today. There's not more evidence or less evidence after today. It's simply you lose the ability to withdraw your plea if you don't like the sentence that you get, which is sort of what happens at trial. If you go to trial and you're found guilty, you don't get to say, wait a minute, I want to take all that back and go to trial again. Do you understand what we're doing today?
Yes.
Okay. Ms. Clark, what is the state's offer if Mr. Walls wanted to enter a plea to these two cases? What would the state be recommending?
The state has offered a global resolution of this case, 20 years to serve 10 in confinement.
Okay. And that would resolve both cases?
Yes, sir.
All right. Is Mr. Walls a recidivist?
He is, sir.
This would be a recidivist sentence, or you would not be seeking to impose any recidivist requirements at this point?
If the global resolution happened, we would seek to withdraw that.
Okay. Is Mr. Walls an A or a C recidivist?
He is an A.
Okay. So 2 or fewer felony convictions.
Yes.
Got it. All right. Any particular?
I'm sorry, he is an A and C because he actually has 3 felonies.
3 felony convictions? Okay. So we're going to talk about recidivism in a minute, Mr. Walls, just so you understand what all that means. Are there any conditions of probation beyond what I'd expect? No contact with the Mitchells or Mr. Anderson? Anything beyond that?
And now also restitution.
Okay.
To the victims.
All right. Got it. Okay. So, Mr. Walls, as I understand it, if you entered a plea today, Ms. Clark would be recommending that across the 2 cases, I sentence you to a period of 10 years in custody, followed by 10 years on probation. Couple things about that recommendation. Number 1, you get credit for time served. I don't know how long you've been in, but every day you've been in would be credited towards those 10 years in custody. And number 2, this is the more important one, those are parolable years, those 10 years. And that's assuming I went along with the state's recommendation. I don't know that I would. I'd need to hear more about the case. But whatever sentence I gave you, if it included prison time, it is parolable as long as the state doesn't pursue that recidivist notice. If they do pursue the recidivist notice and they enter proof of 3 or more felony convictions, and all they need to do is have a certified copy of that conviction, then your prison term is not parolable. So if the same recommendation was made, 20 to serve 10, that would be 10 years to the door. You would not be eligible for parole at any point during those years. And I share that with you, not to spook you about today, because the state's not seeking to recidivize you today. But if you decide to go to trial, I fully expect that the state would, at the end of trial, if you're found guilty, they would tender those 3 convictions and say, Judge, he's a recidivist, and any prison time I give you is non-parolable. So 2 questions for you right now. 1, do you understand what the state's recommendation is?
Yes.
Okay. And 2, do you understand that today that prison term, if I were to impose it, would be a parolable prison term?
Yes.
Okay. You understand? I guess it's 3 questions. If you go to trial and the state does pursue that recidivist notice, any term of imprisonment that I impose would be non-parolable. You understand that?
Yes.
Okay. Understanding all those things, Mr. Walls, do you want to go forward with a guilty plea in one or both of your cases today?
Oh, that's my counsel. No. My lawyer says no.
Okay.
I don't agree with my lawyer.
Okay. Your lawyer is someone you can certainly rely on. I want to make sure you had a chance. It's not just, this is the first time you're hearing Ms. Feely say, no, don't do that. The 2 of you have spoken about your cases and she has given you her advice as to which way you should go on this. Is that correct? Okay. And your election is that you don't want to enter guilty pleas at this point. I will move your 2 cases to trial calendar. Ms. Clark, this offer of 20 to serve 10, does it expire today? Is that an offer that Ms. Feely and Mr. Walls can think about some more, or where are we?
It expires today, Your Honor.
Okay. Mr. Walls, so that we have some scheduling clarity, your two cases will be on the November trial calendar, which is we call the calendar, I think, on November 8th. And we actually start trial that following week. So that's not too far off, but just know that you'll need to be ready to go to trial that week of November 8th. And let me see one other thing. You've been in for a long time. You've been for over a year. So your case is going to be a lot higher up on that list than someone who's on bond or who has been in jail for 6 months. I share that with you to let you know that November 13th could well be a trial date. That helps focus the mind. I've shared with you how things may be a little different come trial time, maybe a different offer from the state. They may not withdraw the recidivist notice so that whatever sentence I impose is non-parolable. But you've told me you understand all that, and I know that you are in the able hands of Ms. Feely, who has done cases like this before. So, Ms. Clark, anything else from the state side?
Your Honor, I just wanted to make a correction. The second victim is actually Mr. Ryan Adams.
Okay.
So please pardon me on the name.
Okay. Understood. Hopefully, Mr. Adams took no offense. Ms. Feely, I should have asked, and I didn't, if you have any discovery concerns as we hurdle towards a trial date.
I do not.
Okay. All right. Good. Then we are all set to go, Mr. Walls. I will see you on November 8th. You'll be brought over here. Again, that's not when the trial starts. That's the call of the calendar. That will be another opportunity to resolve the case short of trial if that's what the two sides decide that they want to do. Otherwise, if when I see you a third time, that'll be because we got you in different clothes and we fill the courtroom with potential jurors. Ms. Clark, I'm not asking you to commit at this point, but if we do reach Mr. Walls's cases on that trial calendar, are you thinking that the aggravated assault case would be the one that you try first, or would it be the drug case?
Your Honor, it would be the aggravated assault.
Okay. Well, then you'll need to be working through your victim advocate with the Mitchells and Mr. Adams because the trial implicates them as well. They likely would need to testify. And so please keep them posted of what the schedule looks like. All right.
Yes, Your Honor.
All right. Mr. Walls, any questions about anything that you and I just discussed? No, sir. All right. I will see you on November 8th. Thank you, everyone. And thank you, Mitchells and Mr. Adams, for plugging in a little bit early. The DA's office will be in touch with you as November 8th approaches. All right, I will leave this Zoom up. I'm going to mute what's going on in the courtroom and we will reconvene at 1. Do you have anything left on the final plea calendar, Ms. Clark? We've got Abate, Willingham. You do. You've got one with a different Ms. Clark with an E. And then we just took care of Mr. Walls. So I will see everyone at 1 o'clock. Thanks.
Thank you, Your Honor.
Okay, we should be good. Ms. Rivers, can you hear us from the courtroom?
Yes, I can, Judge.
Great. All right, let's get started. We have a final plea calendar. Positions 1 and 2 were actually on for motions, but there were no motions filed. So powered through Mr. Flint. Position 3, we don't have Mr. Abate here. Are you gonna?
Your Honor, if you could hold for his positions, he'll be up shortly.
Okay, great. We're not gonna be able to do number 3. Is Mr. Parks up?
Yes.
Okay, excellent. Everyone's here. So we'll bring him to the door when Mr. Abate gets here. But Mr. Francis, if anyone is here for Mr. Parks, Attorney Francis is in trial down on the first floor. So we're not going to be able to move that forward. Carrie Henderson. Hey, Miss Henderson, just walking in. Ms. Feely, we'll hold on that till Mr. Abate is here. And then Demario Phillips. How is, that doesn't seem right. I've got Mr. Francis listed as lawyer for both of them.
I noticed that as well.
Okay. Seems late in the game for that to be the case. Let's look that up. Oh, Ms. Nelson says that's correct. All right. Well, the Supreme Court just affirmed a murder conviction of 2 gentlemen who had the same lawyer for their murder trial. So it's happened before, but I don't know about that. Okay, I'll talk to Mr. Abate about that. Next case is Brandon Harris. Mr. Harris is here. Mr. Harris, is Mr. Adams your lawyer? How many minutes late? 20. Okay. Well, he's not late yet then. Okay. All right. Well, we will hold for him. In fact, his office contacted my office. I just got a note saying that he's working his way this way. Ms. Willingham, have you had a chance to interact with Mr. Adams at all about this case?
I did send him an offer a while back.
Okay.
I spoke with him earlier today to see if he had a chance to review it. It kind of escaped me that I emailed it to him, and I probably should have called Mr. Adams.
Okay.
But I do believe in my last conversation with him, I think that he was gonna plan to speak with his client today.
Okay. Well,
I'll hang around.
hopefully he'll get here. Sir?
Yes, Your Honor. My son, Kamara Parks, supposed to be in court today. And, Mr. Francis is the attorney. I'm trying to find out how did it come up to be a plea deal when he did his first time coming to court?
It's not a plea deal. The calendar is called final plea, and all that we do on final plea, you may get to see it with someone, but we need to have lawyer and client both here, is the last chance for someone to enter a plea and have the ability to withdraw that plea if the sentence that I impose is more severe than what your son's lawyer asked for. So your son's case is complicated for lots of reasons, but for final plea reasons, we usually don't resolve cases today because the state says, sure, I'll offer life. Most people don't plead to life. But we can't do that without Mr. Francis here. But I don't want you to think, oh, yeah.
I want you to know we got pictures and everything.
Okay. And we're not going to get into evidence of the case, but there may be very strong defenses for Mr. Parks. Today was simply an opportunity, if someone wanted to try to resolve a case with a plea, to tender that plea, then they'd find out what sentence I'm going to give them. And if it's a worse sentence than their lawyer asked for, they can say, oh, I was okay with 5. I don't like 10. No, thank you. But with murder cases, that rarely happens because if you're pleading and the state's recommending life, I can't give you less than life if that's what the state is doing. Sometimes they'll reduce it. It'll be a plea to aggravated assault or voluntary manslaughter. And then there's a little give in it. But we're not doing anything with your son's case other than that I promised to address him, let him know why he was brought over, because his lawyer is stuck in trial. Okay, so he will be brought out once we get the prosecutor here. Sure. All right, so Mr. Harris is here, his lawyer's on his way. We took care of Mr. Butler this morning. That gets us to Emmanuel Hinton, and our two clerks. Mr. Hinton is here and up. Okay. I usually only use last names, but so we're clear on the record. Angela Clark, good afternoon.
Good afternoon, Judge.
Do you need to speak with your client, or are we ready to do the final plea hearing for Mr. Hinton?
I was going to ask that the final plea be continued, Your Honor. I know his case has been around in the system for a long time, not with you, but we had a deal worked out with Madam DA that fell through and was rescinded because of a new charge. And the new charge is a new armed robbery, and it has not been indicted yet. I haven't had a chance to do the preliminary hearing to see if we can do a global type of resolution.
Okay.
But the prelim is set for later this month.
Got it. So I think I follow you, and we'll bring Mr. Hinton out in a moment to talk through that, but this is helpful for me to understand. So this armed robbery, the new charge, I guess, has to have been a little while ago, because he doesn't have bond, your client, in this case.
No.
But I guess he had bond at some point.
He did.
Okay.
He was out for a couple of years, Your Honor.
Oh, look at that. I see. Because this is from 2021.
Right.
Got it. And it magically wasn't indicted until more recently.
Yes.
Okay.
When, after the new charge occurred, they indicted it,
Okay.
but not before that.
Got it.
And he had been out on bond. And,
Okay. And this other case was rattling around in the system, the one that is do you have the CP number?
I do, Your Honor. You had a bond hearing on September 19th and said, no, you would not reinstate the bond.
Oh, for this case?
Yes.
Because of the other charges?
Right.
Okay. And what's that case?
Let me see. Do you have it on? I have it.
I think I found it. It's 23 CP 218423.
Okay, thanks.
Let's see. Yes, so the prelim is in 7 days. It's on the 24th. It was reset once because the officer didn't show up. So this is the state's last chance. But your point is a great one, which is we should try to come up with a global resolution for Mr. Hinton.
Yeah.
I'm never a big fan of saying, let's slow this one down so I can catch a new case. But I am a big fan of, especially when we're working with someone Mr. Hinton's young age, to just get one overall impact for him and the various victims in his cases. So, have you, Angela Clark, spoken with Christina Clark about a global resolution? Because Christina Clark could always reach into the system and say, if Mr. Hinton is waiving indictment, we could accuse the other case in whatever charges it would be, rather than waiting on the unknown of when might the state get around to indicting.
Well, no, Your Honor, I haven't spoken to her. I was on FLMA until yesterday.
Oh, well, welcome back.
Thank you. But without having a prelim, I don't know what the evidence is to try to negotiate, or if what you said makes sense.
Got it. Meaning you would like to hear the prelim.
At least.
Okay.
So that I could have some idea of what it is that they think they have against my client, how they arrive at him.
Sure.
It's-
So here's what I'm proposing, and then I want to hear from Prosecutor Clark as well, is that we reset this for an inquiry calendar about a month out that gives Defense Attorney Clark an opportunity to have this preliminary hearing, learn more about the case, and be in a better position to advocate on behalf of Mr. Hinton, whatever a global resolution may look like. It may be that the magistrate finds probable cause to bind over the charges, and there Mr. Hinton sits with no bond and an unindicted armed robbery, aggravated assault, etc. I don't want to wait forever on that, but we could reconvene in a month and take everyone's pulse about the likelihood of a global resolution. And if that seems unlikely, then I'll want to move forward with this case, which, while is a new indictment, is not a new set of facts. And so we've got victims out there who are looking for closure, and Mr. Hinton's not getting any younger, just sitting around waiting. Does that work, Prosecutor Clark, for you?
Yes, Your Honor.
Okay. And Defense Attorney Clark, I'm going to bring Mr. Hinton out right now, but you're okay with that plan?
Yes, Your Honor.
Okay, if we could bring Mr. Hinton out, please.
I'm sitting between.
Good afternoon, Mr. Hinton. How you doing?
Good.
Good. Mr. Hinton, I was just talking with your lawyer, Ms. Clark, as well as the prosecutor, also a Ms. Clark, about your situation. And I had forgotten, but this did come up when we had a bond hearing in your case, but your lawyer reminded me, you have another armed robbery allegation that's out there that's not indicted yet. Next week at this time, you are going to have a preliminary hearing. Ms. Clark, your lawyer, will be there. You'll be there, obviously. And the state will need to put up some evidence to try to convince a judge, not me, a different judge, that there's probable cause that your charges should move forward. So it's not really a trial, but your lawyer will have a chance to ask a detective or a police officer questions about this other set of charges. That's going to give your lawyer a chance to learn more about that other case, because she, having your best interest in mind, wants to make sure, if she's trying to come up with a way to resolve the case that you and I have, a different armed robbery, that maybe there's a way to resolve everything. But in order to do that, she needs to understand, well, how strong is this other case? She's got discovery in the case I thought we were going to talk about today. And so she's already decided, may have talked to you about how strong or weak the state's case is. Should you go to trial? Should you try to work it out? But now you got this other armed robbery, allegedly. And your lawyer needs a chance to assess that as well, so that then she can get with the prosecutor to say, I think we could work this out. It may mean a little more time for Mr. Hinton because it's two cases, but let's see if we can sort it out. That's going to take a little while. And importantly, we need to do that preliminary hearing next week first. So instead of doing what I thought we were going to do today, where I'd find out, are you resolving your old armed robbery and carjacking. Something happened way back in 2021. Ms. Clark, your lawyer, has said, let's see if we're going to resolve both of them together. So I'm going to have you come back here a few weeks after that preliminary hearing to get an update from your lawyer and the prosecutor about what we may do with your cases. All right?
Yeah.
Does that make sense?
Yeah.
Any questions for me? Okay. Angela Clark, anything else you want to get in front of me concerning Mr. Hinton?
No, Your Honor, I really want to find out about the second armed robbery so that we could see where we're going with that, if they find probable cause or do not find probable cause.
Got it. Okay. Prosecutor Clark, anything you want to add?
No, Your Honor.
Okay. Well, thank you, everyone. Mr. Hinton, you'll come back to court in about a week. Again, you won't be seeing me. Your lawyer will be there, be a different judge, and it's Judge Manning? Could be, probably Judge Drake. It'll probably be Judge Drake.
It says 1A, so that's Manning. Judge Drake is 2B.
She is 2B usually, but preliminary hearings are usually with Judge Drake. But I don't control that. Could be Manning, could be Drake. It's going to be a judge, someone in a robe. And that judge will listen to the evidence and decide, yep, there's probable cause or not. It's not guilty, not guilty. There's no sentence that flows out of it. Just the next step in that other case. And your lawyer wisely wants to get past that before we figure out where we resolve everything. And the other thing you should know, if that other case gets indicted, gets in front of a grand jury and they say, yep, we're going to indict Mr. Hinton for that other armed robbery, that will come to me because I've got this case. We try to have a defendant, all the defendant's business, all in front of the same judge once it's at the level of an indictment. So don't be surprised or disappointed or excited if your new case, if it gets indicted, if it comes here. That's how it's supposed to work. Okay? All right. Thank you.
Do you have a date or are you going to?
I don't. Ms. Nelson will get that date, but I'll make sure that it's about a month out. So you've got time to digest what you learn next week.
Thank you.
Sure.
And I could speak with the prosecutor because initially this case was not supposed to be indicted. It was after speaking with Madam DA, it was going to be resolved.
Oh.
But then a new charge came up.
All right. But that means it may be together resolvable. We'll see. Okay. All right. Mr. Abate, you are here. Good afternoon, sir. Mr. Parks, we can't deal with today because Mr. Francis is in trial. Similarly with Mr. Phillips, which caused me to recognize that Mr. Francis is listed as attorney of record for co-defendants. Is that I know he has Mr. Phillips because he argued an immunity motion. So he's clearly locked in there. Is it your understanding he also represents Mr. Parks at this point?
I don't know. That was not my understanding.
Okay.
I know I served discovery to a separate lawyer for Mr. Parks.
Let's look it up.
So Mr. Parks had a couple lawyers last year.
Okay. So on August 9th of this year, Dennis Francis filed an entry of appearance for Mr. Parks. So we'll need to have a conference with him to sort out that apparent conflict and make sure, having just had to deal with a motion for new trial that was affirmed by the Supreme Court, where Dante Hudson represented two people at trial. That's fraught, as you know. Yes. No, the Adams' brothers, Isaiah Adams and Leon Adams. Yeah, right. So I don't want to go through that personally. That was a different judge who let that happen. So we'll need to work through that, but we can't advance either of those because Mr. Francis isn't here. Since you're here, I'm gonna have each one of them come to the door just to let them know. But then we have Ms. Henderson is here and we need to figure out what, if anything's gonna happen, this final plea with Ms. Henderson. And I think that's it for your business. So if we could start, please, with Mr. Parks.
Thank you.
Parks. What do you mean parks? Parks.
Hey, Mr. Parks, you can stay right there. This is going to be quick. I'm Judge McBurney. We met before, and we were supposed to have a conversation about your case today, but your lawyer, Mr. Francis, is in trial right now. We didn't know he was going to be called out for trial, but he is in front of another judge in this building handling a case. So we're going to need to reset this not far into the future, but it's not right for me to talk to you and the prosecutor about your case without your lawyer here. But I wanted to let you know why you got brought over, and it wasn't to waste your time. We just didn't know Mr. Francis would have this conflict. Okay?
How long it take me to get another court date?
No, but it ought to be soon. Once he's done with the trial, we should be able to bring you back here. It's easy to get you here. It's hard to get Mr. Francis here. But he's got to finish that trial. And I got to tell you, we're going to need to work out. He is listed as being your lawyer as well as Mr. Phillips's lawyer. And Mr. Phillips is your co-defendant in this case. That's usually not how we do things. And if it's going to work that way, I have to have a long conversation with you and Mr. Phillips where both of you say, oh, I don't mind that we have the same lawyer. Generally, defendants want a lawyer who is focused just on them and not on another guy as well, because you could have a situation where your defense is, I didn't have a gun, he had the gun. And you can't have the same lawyer defending that. So I don't want you to panic. If Mr. Francis ought not to have filed an entry on your behalf, get you a different lawyer. But we need to sort that out, which means we need Mr. Francis here. So you asked the right question. I'd say it's just in a few weeks. He's got to finish that trial, which is going to spill over into next week. And then we get on his schedule and get you back here. Okay?
Thank you.
You bet. Mr. Betha, I think I'll send an email to you and Mr. Francis saying what's happening with these two cases. He may just not have appreciated, because his entry was so recent with Mr. Parks, that he's already in pretty deep with Mr. Phillips.
I'll be honest, I didn't appreciate it either. I didn't even recognize it.
Okay. If we could bring Mr. Phillips out, and I'm remembering correctly, Phillips is the one who had the immunity motion and Judge Dempsey denied it.
That's correct.
Okay. And in just a moment, Ms. Henderson, when I'm done talking with Mr. Phillips, I'm gonna have you come up and sit with Ms. Feely, okay?
Right here. Come on here. Just have a seat.
Hey, no, he can, or you can take a seat, that's fine. Hey, Mr. Phillips, how you doing?
Good.
You know me, I'm Judge McBurney. Your case is assigned to me. And we were supposed to have a conversation today about whether this is a case that's going to resolve short of trial, or if we should get a jury in here and have a trial in your case. That's an important conversation, and we're missing an important person to have that conversation, and that would be your lawyer, Mr. Francis. He is in trial in another courtroom here in this building, and so can't be here. So we're going to need to reset this for a few weeks. His trial may last a couple weeks. When that wraps up, then we'll get him in court along with you so we can have that conversation. That was supposed to happen today. I didn't know about this conflict, and it didn't really flesh out until yesterday when the judge called in Mr. Francis's trial. Any questions about that?
Yeah. I went for immunity hearing. They ain't granted, or they ain't denied yet. So I'm still waiting to see what's going on.
Let me break the news to you on that one. You did have an immunity hearing in front of Judge Dempsey, who was a colleague of mine and then took senior status, which means he kind of retired, but he comes back to do important stuff like your immunity hearing. And he did rule on it. And just recently, 4 days ago, and he denied the immunity motion. So he heard the evidence about you and Mr. Parks and G walking through Notting Hill neighborhood towards Mr. Parks's house, and shooters yelling things, and you and Mr. Parks and G supposedly shooting in the direction of this address. And his conclusion was that it was not self-defense to the level that your prosecution should be dismissed. Doesn't mean that Mr. Francis can't argue self-defense at trial, but it didn't reach the level that Judge Dempsey felt that this case should be thrown out. Okay?
Yeah.
And Mr. Francis will come talk to you about that. My guess is that he intended to do it. This order just came out, but then he got called into trial in this other courtroom. Okay? All right. We will see you soon to have that other conversation. Mr. Parks's father, you all didn't hire Mr. Francis. He was appointed to represent your son, or did you pay him money? He was appointed. He was appointed. Okay. That's what I thought. All right. Ms. Henderson, if you'd come up, please, and sit with your lawyer, Ms. Feely.
Actually, we speak with your body before we.
Oh, okay. Take 5. Why don't we, is Ms. Woods, you need me? Yeah, well, I see Ms. Sellers here, so that's how I knew, but I don't see Ms. Wood. Are you gonna handle Betha, or is Ms. Wood coming back?
I'm here, Judge.
Oh, she's on Zoom, okay. So why don't you talk with Ms. Henderson? We're still waiting on Mr. Adams. He's now late, but we'll reach out to figure out what the deal is. You wanna go check on him? Great, that's fine, just make sure you come back. And we can talk about Mr. Betha. Ms. Sellers, you're handling Mr. Betha's case?
Well, as I understand, Mr. Betha is now competent.
I think that's the latest situation. Yes, ma'am.
Yes, and I've been in communication with Ms. Wood as it relates.
But it's not really stand trial, it would be stand probation revocation hearing. Okay.
Yeah, so as I understand, just from our communication, that he is, he does have bed space, and I think Ms. Wood, attorney, will be able to shed more light onto what's happening.
Got it. So I'm happy to bring Mr. Betha out, but only after I know what the game plan is, so I can help manage him. Are we at a point, given how long he's been in, that this is a resolvable revocation, or what's your sense, Ms. Wood?
Yes, Judge. So that's my plan. I just got an update from Ms. Ross. Viewpoints is accepting him. Now it becomes a logistics issue of making sure they have a bed for him. He has been in over a year. I don't know if the court would prefer to handle it today and hold off on doing the transport order until a bed space becomes available. I'm not sure what would be best.
So if Ms. Sellers is in agreement that this is the right disposition, in other words, it's a negotiated disposition, my thought is we do it today. And then once you give me notice that there's a bed available, then I can enter the order so it can be a release to situation. That way we don't need to drag Ms. Sellers back or Mr. Betha over here. If this is a non-negotiated situation, we could still do the hearing, and I'll figure out what I think is a reasonable revocation in this instance. And then if it happens to be one that is consistent with getting him to viewpoint, again, I'd sit on issuing the final revocation order until we know viewpoint could take it.
Yes, Judge. And
okay. Ms. Sellers, are you in a position to go forward with the revocation hearing?
I just needed to get a little bit, I wasn't aware this case was on the calendar today.
Okay.
I just wanted to review the warrants, the probation warrant petition.
Okay. So take a minute. We're not rushing anyone, but we can certainly manage this one while we're waiting on the other. And I think, Ms. Clark, you're all, if Ms. Sellers is going to handle Betha, then you've done all you need to do today.
All right, okay.
Take care.
Interesting 2 weeks, that's for sure.
Ms. Sellers, you're looking at the probation warrant from August 15th of last year?
I was trying to look for it, Your Honor.
Okay, I've got it. I'll print it out. I think that's the only warrant we're dealing with.
Is that, he has a new, was it a misdemeanor charge?
He was released from Hancock State Prison, didn't report, field visit. It was basically absconded. But I don't know how familiar you are with his past, but it's complicated and high profile. And so a mere abscondment, whatever the noun would be, was significant enough that we all wanted to make sure we were thoughtful about what came next. I can print, do you need a copy of it? Ms. Wood, is that the warrant you're aware of? That's the only one I could find. Or is there? Pardon me?
That is the only one I have as well.
Okay. The printer's not real happy right now, so just trust me, that's what it says. Here, I'll do this. Is the prosecutor screen on there?
Yes, thank you.
You bet. I know it's a little small, but I don't know how to.
Oh, no, it's fine.
That how it's bigger. Any luck?
15 minutes ago.
15 minutes from now?
Like 5 minutes.
Okay. All right, so I'm ready to go forward on Betha or Henderson. I'll give Mr. Adams a little more time. Do you need more time, Ms. Sellers, or are you?
A little bit. Is probation on this?
Yes, I think Ms. Tucson should be on. Let me drop this. She is? Did you have a question for probation?
Yeah, I'm having a difficult time pulling this up. It's not pulling up.
Pulling what up?
Pulling the case up, or our case up.
Oh, in your system?
Yes.
Okay. This would be 58th offender. Not sealed. Hey, Ms. Feely, we are stuck on Betha right now. Are we able to do Ms. Henderson's final plea?
I believe so.
Okay, well, let's get it. We'll give it a try. Ms. Henderson, if you'll take a seat next to Ms. Feely. All right, let's get on the record. This is position 4 from our final plea calendar, 21 SC 180098, State versus Carrie Henderson. Ms. Henderson is represented by Ms. Feely, who's seated beside her. Mr. Bate represents the state. Ms. Henderson is a co-defendant with Mr. Phillips and Mr. Parks, but she is charged only with making a false statement and criminal solicitation for something. You look at the indictment, but either way, two much less significant offenses than the murder charges that the two gentlemen face. Ms. Feely, I'm confident you've got all the discovery.
Yes.
Good. Okay. Mr. Bate, what is the state's offer, if there's an offer for Ms. Henderson at this point?
At this point, I would say there's an offer, we could go non-negotiated. I think it's probably be more beneficial for Ms. Henderson if me and Ms. Feely continue to negotiate to see if this would be a case where she is a more appropriate witness than defendant.
Okay. So my thought, and I'll hear from Ms. Feely on this, is that we move Ms. Henderson's piece of the case to the trial calendar, not alone. It wouldn't appear on its own, but we stop making Ms. Henderson come back for final plea and other things like that. She would next appear when Mr. Phillips and or Mr. Parks are on a trial calendar. Okay. Ms. Feely, tell me your thoughts about that.
I think we haven't had an offer to consider yet at this point, given the posture of the other two cases. So I think that would be our request as well.
Okay, so Ms. Henderson, the charges are still there. I know this is a complicated case for you, given who the defendants, other defendants are. You're welcome to come to court every time either one of them is coming to court. You're not prohibited from that, but we won't be talking about your part of the case. We've already had the immunity hearing for Mr. Phillips. That's done. And so there are only two pieces left for him. It's final plea, where we see if there's an offer and he wants to take it or not. And then it's a trial. And I may actually just move it to the trial calendar so that if he's going to enter a plea, we could do it. But otherwise, we get him a day in court. Mr. Parks is a little more complicated because of this joint representation that's going on. And I need to work through that. But this case is old and folks have been in jail for a long time. So I'm anxious to move it along. Did you have a question?
No, the desire.
Okay, all right. So you remain out on bond. It's a little bond. Make sure you continue to comply with bond. If you move for any reason, let Ms. Feely know because we need to be able to track you down. If you suddenly disappear, you've done great so far. Keep doing great and make sure you let folks know where you're staying and don't miss court dates. But your next required court date will be to show up for trial. But like I said, you're of course welcome to come to any court date for either of the co-defendants, okay? All right, Mr. Betha, anything else in the Parks, Henderson, Phillips matter? All right, Ms. Feely?
No, Your Honor.
Okay, thank you. So, Ms. Sellers, got an update for me? Okay. If we could bring Mr. Betha out, please. I think you all would prefer that he sit next to Ms. Feely. His lawyer is virtual.
Okay.
But I think it just, if he's okay sitting, I think it would be better if he sat in front of that screen.
That'd be better if you see.
You have a seat right here. Right here.
Good afternoon, Mr. Betha.
Good afternoon.
How are you? Good. Mr. Betha, we're gonna have the long overdue probation revocation hearing in your case. Are you ready to do that?
Yes, sir.
Okay. This is case 16 SC 142024. Mr. Betha is here in court. His lawyer, Ms. Wood, is appearing virtually. You should be able to see her on that screen right in front of you.
Sir, yes, sir.
In fact, I'm going to add you to the screen as well so people can see each other. There's Mr. Betha. Fantastic. And we have Ms. Sellers representing the state in this matter. Mr. Betha, you've been in jail for a long time on this probation warrant that I signed back in August of 2022. The allegation in the probation warrant is that when you were released from state custody, you had been staying at Hancock State Prison. When you were released, you didn't plug in or report to probation.
Sir, yes, sir.
And they couldn't find you. And of course, you and probation staying connected is real important. That's one way we can be sure you're taking the medicine that I know you want to take, and it keeps you in a much better frame of mind than when you don't have that medication. That's it. That's the only allegation. Not that you hurt anyone or did anything else. It's that you didn't report to probation. And that's what we're trying to fix going forward. Ms. Wood, is Mr. Betha admitting to the allegation in the petition or the warrant?
Yes, Judge.
Okay. Ms. Tucson, how much time remains on probation for Mr. Betha in this case?
Hello, he has, where did he go? Oh, that was from this morning, right?
Yes, it's the last position on this morning's count.
Okay.
Yeah.
He has 2 years, 4 months, and 15 days remaining on this case.
Okay. If I were, Mr. Betha has been in for more than a year. If I revoked a year, but gave him credit for time served, would that mean that then he would only have 1 year and 4 months left? In other words, the revocation subtracts from the time remaining, or if I'm giving him credit for time served, it does not subtract from the time remaining?
It won't subtract.
It
It will
will
subtract if you gave him credit for time served and suspended it, right? Because then he would have done that whole year. But I think if it just revoked he credit for time served, it's still going to remain.
The 2 years and 4 months.
Yes.
Okay. Ms. Wood, what is your answer to that question based on your experience?
I am confused now, judges. Is Ms. Tucson saying that he has, even after he's sat in custody for the year that he's been in, he now has 2 additional years? Is that the correct understanding?
That's correct. His probation sentence ends March 4th, 2026. That is his sentence for probation. So that's the 2 years, 4 months remaining on his case for probation.
Okay. So if I reinstate the balance, then that's what's left.
Correct.
Okay. Thank you. Ms. Wood, are you less confused now or even more confused?
No, Judge, that's helpful. And he has been in 424 days. Oh, is it my turn to speak, Judge? May I continue?
Sure, you can dive in. I just wanted to understand the math. I'm inclined to have Mr. Betha have a meaningful window of probation because of the program that you've been able to line up for him so that we can maintain that. That's the only reason why I was asking.
Okay. Yes, Judge. So he has been in 424 days. It has taken us a bit of time to get to this point. There were some competency issues. He's now doing well. He's stable. He's taking his medication as prescribed. And I just got word from Ms. Ross. He was accepted into Viewpoint Health, their inpatient program. Now we're just going to wait on a date certain for them to transport him. So we would ask that you revoke 1 year and credit for time served and reinstate to probation.
Okay. And the Viewpoint, hello, Mr. Adams. The Viewpoint Health program that's inpatient, which is great. So there's a room for him, a place to stay, meals to eat, etc. Does it have a particular duration or it's more of a maintenance program?
Judge, I believe it's maintenance, but I will confirm all of that with Ms. Ross. I know she just got out of the meeting with them.
Okay. All right. Ms. Sellers.
Yes, Your Honor.
What's the state's recommendation?
State agrees with the defense's recommendation to revoke a year in condition of the time that he is served. For it to be a condition of his probation for him to remain in a Viewpoint program.
Okay, great. Until discharged. I mean, presumably a Viewpoint says, hey, you're in a position now where you could be in an outpatient setting. Okay, got it. All right. Ms. Tucson, is Mr. Betha on probation in any other cases? I noticed in finding this case that there are newer cases, meaning the indictments were handed down more recently, that are closed. I want to make sure he doesn't have other things that will trip him up if we're trying to get him to Viewpoint.
I'm double checking to my knowledge. there's nothing else that's active for him. So everything else is expired.
Got it. Okay. Well, that's helpful to know. So, Mr. Betha, do you have any questions about what we've been discussing?
So, no, sir.
All right. Mr. Betha, I find that you violated the terms and conditions of your probation when, after you were released from Hancock State Prison, you didn't make an effort to connect with probation.
So, yes, sir.
And as a result of that, I'm going to revoke 1 year of your probation,
So, yes, sir.
but I'm giving you credit for the time you've already served, which is more than a year. And I will reinstate the balance of your probation. Special condition of probation number 1 is that you participate in Viewpoint's inpatient treatment program until you are discharged. In other words, that's where you're going to live. And those are the folks who are going to help take care of you. You don't walk away until they help you maybe find your own place. But it's not that Mr. Betha says, I'm done with this, I'm going to go somewhere else. Okay?
So, yes, sir.
Number 2, special condition is that you will continue to take all prescribed medication. If a doctor says, drink this, take this pill, you're going to do that because that helps you be in a much better place than when I first met you. And things were pretty complicated for you.
So, yes, sir.
I'm going to waive your probation supervision fees as long as you are on probation. And I will request, I can't require it, but I will request that DCS assign a probation officer, a mental health probation officer who is attuned to working with your situation. Ms. Sellers, anything else you'd like to see in that revocation order?
Nothing further from the state, Your Honor.
Okay. Ms. Wood, anything else?
No, Your Honor, thank you.
Will you tell Ms. Ross, thank you for the work that she's done. This has been a long time coming. Mr. Betha's situation is complicated. And if we can keep him stable, that's going to be a lot better for Mr. Betha and everyone around him.
Thank you, Judge.
All right. So Mr. Betha, I'm going to sign that order as soon as that bed opens up. So you may be back at the jail for a couple more days. But once they call your lawyer and say, we're ready for Mr. Betha, I'll sign the order and they'll transport you to that location. Okay.
Okay.
All right. Thank you.
I have a question.
Yes, ma'am.
Just to confirm, because I remember from the last time Ms. Wood saying she was waiting on placement for him. So I have that in my notes. So as far as an address, or anything for him, maybe Ms. Wood, you can get that to me. He is assigned to Officer Hartigan. He actually reached out to me recently, and he is a mental health officer. So he is already assigned to Officer Hartigan's caseload for mental health. So maybe I could get Officer Hartigan's number to Ms. Wood. So some sort of coordination. He doesn't get a warrant and stuff like that when he is at Viewpoint.
Perfect. I will email you.
Okay, sounds good. And at just 1 year revoked, credit for time served from August 19, 2022. And then those special conditions that you just mentioned.
Right. And we're reinstating the balance. So it's the 2 years and 4 months and whatever. And yes, let's make sure you do get that address for Viewpoint because that's where he'll be staying. And that's where we'll want to know he can be supervised.
Okay, sounds good. Thank you.
Thank you. Bye-bye. All right. Mr. Adams, if you and Mr. Harris could come on up either to the podium or to council table, either way. Let's do podium.
Come on, you come around this way. Yeah. You stand right here, and your lawyer stand right here. You stand right here, counsel.
Okay, thank you.
All right, let's get on the record, please. In Mr. Harris's case, it's position 6, 23 SC 186762. Mr. Harris is here in court with his lawyer, Mr. Adams. Ms. Willingham is here. No, I see her on behalf of the state. Ms. Willingham, what are we doing this afternoon? Are we working through what the offer is and a rejection of same, or is it a plea, or you're not sure?
I'm not sure, Your Honor.
All right. Well, Mr. Adams, I'm going to ask you. So this is the final plea date for Mr. Harris. That doesn't mean, as you know, that it's the last day he could take a plea, but it is the last day that he could withdraw his plea if the sentence I imposed was more severe than what you advocated for on his behalf.
Yeah, I think I talked to Ms. Willingham. It is a negotiated plea.
Okay. Is that your understanding, Mr. Harris?
Yes, sir.
Okay. Then Ms. Willingham, if you'll come on up, we will get started. Mr. Harris, the way this will work is that Ms. Willingham in a moment is going to put you under oath. Once you're under oath, you'll need to answer all of her questions truthfully and completely. I'll probably have a few questions as well. If at any time you've got a question, you need to let me or Mr. Adams know so we can try to answer that. I need to be comfortable that you've understood everything that's going on. And I think you will. It's not meant to be complicated, but you and Mr. Adams may have been talking about the case going this way, and Ms. Willingham says something that makes it sound like it's going a different way. Just call time out and we'll make sure you understand, okay?
Yes, sir.
All right, Ms. Willingham, when you are ready, please.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can put your hand down. Please state your name, your age, and your date of birth.
My name is Brandon Terrell Harris. I am 26. I'm 25. My birthday is December 18, 1997.
Are you now under the influence of any medicine, drugs, or alcohol?
No, ma'am.
How far did you go in school?
12th grade.
Can you read and write in the English language?
Yes, ma'am.
Have you had the opportunity to review the document that charges you in this case?
Yes, ma'am.
Do you fully understand the nature of the charges pending against you?
Yes, ma'am.
By pleading guilty today, you're giving up certain rights. The right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand these rights?
Yes, ma'am.
You understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
Yes, ma'am.
The negotiation in this case, as to count 1, aggravated assault strangulation, is 5 years probation. As to count 2, terroristic threats, 5 years probation. As to count 3, 12 months probation. Battery, family violence, 12 months probation. And as to count 4, battery against a pregnant woman, 12 months probation. And all of those counts are to run concurrent. And as to the special conditions, you would need to complete family violence intervention program, have no violent contact with the victim, complete 80 hours of community service, and have no weapons. Is that what was explained to you?
Yes, ma'am.
You're pleading guilty today to aggravated assault strangulation with a minimum of 3 years and a maximum of 20 years, terroristic threats with a minimum of 1 year and a maximum of 5 years, battery, family violence with a minimum of 1 day and a maximum of 12 months, and battery against a pregnant woman with a minimum of 1 day and a maximum of 12 months. Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
No, ma'am.
You heard me tell the court what the negotiation is in this case, which is a total of 5 years probation. Do you understand the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law, which is 27 years?
Yes, ma'am.
Do you understand, however, that if the court does not accept this negotiation, you have a right to withdraw your guilty plea today?
Yes, ma'am.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. You will be required to follow the general conditions of probation that probation will give to you when you meet with them, including, but not limited to, that you are not to violate the criminal laws of any governmental unit. Under the special conditions, as previously stated, you would need to complete family violence intervention program, have no violent contact with the victim, complete 80 hours of community service, and have no weapons. Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes, ma'am.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes, ma'am.
Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
No, ma'am.
Are you satisfied with what your lawyer has done for you in this case?
Yes.
Do you have any more questions for your lawyer before we go on?
No.
Have you understood everything I've asked you so far?
Yes, ma'am.
Understanding all of your rights, do you wish to enter a plea to these charges today?
Yes, ma'am.
Is your decision to plead guilty made freely and voluntarily?
Yes, ma'am.
Did you in fact commit the offenses to which you are pleading guilty?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
If you wish to challenge this plea for legal error, you have one of two ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition. You will have 4 years from the date the sentence is entered for the felony offenses, and you will have 12 months from the date the sentence is entered for the misdemeanor offenses. Do you understand these time limits?
Yes, ma'am.
Do you understand that you are not allowed to possess firearms during the course of your probation?
Yes, ma'am.
Do you understand if you are found in possession of a firearm, you could be charged with another felony, which carries up to 10 years in confinement?
Yes, ma'am.
Your Honor, if the state were to proceed forward with trial, the state would prove beyond a reasonable doubt that, I'm sorry, I need to go back to the incident date. My apologies, Your Honor. That on December 10th, 2020, Officer McDonald was dispatched to a home regarding an assault. Officer McDonald spoke with Miss Ashley Raphael, who stated she was assaulted by her live-in boyfriend, Brandon Harris. Miss Raphael stated her boyfriend was upset about her spending $140 to try and get their vehicle fixed. She stated Mr. Harris grabbed her phone, cursed her, then walked away from her. When she tried to get her phone back, Mr. Harris became angry and put her in a headlock. She stated she was being strangled and could not breathe. She tried to get away, but was unable to. Mr. Harris was hitting and punching her while keeping his arm wrapped around her neck. She stated she blacked out when she woke up and realized she was on the floor. Mr. Harris told her he would kill her and left before Officer McDonald arrived. Mr. Harris continued to text and FaceTime Ms. Raphael after he left, calling her a fat bitch and telling her that she needed to be out by 9:30. Officer McDonald observed marks on her neck and bruises on her chest, arm, and blood on her head. Ms. Raphael also sustained a tongue injury and lacerations on her body. She was seen by the EMS and waited for her mother to arrive to take her to the hospital. She has now delivered their baby since this incident. Your Honor, I have had an opportunity to speak with Ms. Raphael, and she, against my better wishes, would like to have no violent contact. However, it is for the sake, she said, of their child. She believes that the defendant needs to be out mainly because he needs to help financially support their child. They are not together anymore, it is my understanding, but she does want no violent contact as she does not wish to hinder him from having any communication with his child. And she doesn't believe they have a third party that is going to make that easy.
An aunt that they could leave the kid with and, okay.
Yes, I checked to see if there was any third party, and she stated that that often just complicates things even more for them.
Okay, got it. Thank you. Ms. Jackson, good afternoon. Can you share with me, please, whatever criminal history information you have on Mr. Harris?
Yes, Your Honor. He has 4 cycles. The last arrest was June the 2nd, 2021 in Fulton County for a probation violation. He did receive first offender treatment in 2018 for aggravated assault and possession of a firearm during commission of a felony. That case was sealed August the 10th, 2023. Nothing in addition, Your Honor.
Thank you. Mr. Adams.
Yes, Your Honor, we believe those would be the facts. We'd ask you to accept the recommendation.
Okay. Mr. Harris, you and Ms. Raphael are not an item anymore?
No, sir.
Okay. You see her in connection with the kid you have together, boy or girl?
Girl.
What's her name?
Zaya Raphael.
Zaire?
Zaya, XYA.
XYA, Zaya, cool name. So Zaya, in order to see her, you have to interact with Ms. Raphael.
Right now, I had to go through other ways to contact her and get my daughter due to the case.
Okay.
But my brother was helping me with that.
Got it. Oh, because a condition of your bond was no contact with Ms. Raphael. All right. Well, that's going to change as we go forward. But it sounds like you and Ms. Raphael have gone in your own directions.
Yes, sir.
Do you have other kids?
No, sir.
So Zaya is your one child?
Yes, sir.
Have you been able to see her over the last, it's been almost 3 years.
Not as much as I would like to, but.
Okay. Well, it sounds like Ms. Raphael is okay with you seeing her more. And that's a good thing for Zaya. What do you work?
I was working, I had a failure to appear, remember?
I do.
Back in June.
Yeah.
I was working, probably up in 2 years straight up until then. When I went to jail for that, I lost my job. I haven't been able to find that since then.
What work were you doing back then?
I was working at a Raleigh auto part warehouse. I was a driver delivering parts to the stores.
Okay. All right. But since then, you haven't been able to find something.
No, sir.
Do you stay with family or your own spot?
Me and my girlfriend have a place in Forest Park. The new address I updated.
Okay. That's not Ms. Raphael. It's a different lady.
Yes, sir.
Okay. All right. You have any questions about anything we've discussed?
No, sir.
Okay. Well, Mr. Harris, I find there's a factual basis for your plea. Your plea is knowing and voluntary. No one's forcing you to go forward with this. It's good to put it behind you. It happened a long time ago. I'm sentencing you under the Probation Options Management Act. And all that means is that while you're on probation, if you have a minor situation with probation, you and probation will sort that out. You don't have to come back and see me. But if you get arrested for anything or there's any misconduct involving Ms. Raphael, that'll come back to me and we'll work through the consequences. Mr. Adams, can someone on my staff sign the indictment on your behalf?
You may yell.
Ms. Willingham?
Yes, Your Honor.
Okay, and can we sign for you, just indicating your guilty plea, Mr. Harris?
Yes, sir.
Great. All right, I will follow the negotiated resolution and sentence you on count 1 to 5 years, count 2 to 5 years, 3 to 12 months, and 4 to 12 months. Those will all run concurrently with each other, meaning at the same time, and they'll all be probated. So it's effectively a sentence of 5 years probation. Special condition of probation number 1 is that you complete a family violence intervention program. That's a series of classes, not just one class, that are designed to give you good tools so that when you might encounter relationship difficulties, whether it's with your daughter or your girlfriend or someone else, you manage it a little differently than what happened back in December of 2020. Second condition is no violent contact with Ms. Raphael. So after this afternoon, you can call her. Doesn't mean you need to be all up in her business, but you can call her and say, hey, can I see my daughter? If you guys have tension, make sure you dial it back because it needs to not end up like this. And then finally, you'll need to do 80 hours of community service. You don't have to do that all at once, although you're not working now, so you may want to knock some of those out. And it doesn't mean picking up trash on the side of the road. If you can find a volunteer opportunity that you are passionate about, just make sure that probation will give you credit for it, and you'll be able to do that. I will set what's called a behavioral incentive date of 3 years from now. So that would be October 18th of 2026. If by that date you've done your community service, you finished your family violence intervention program, and you've otherwise stay out of trouble, they can shut the case down. Okay?
Okay.
Yes, sir.
Yeah, one thing, he does have an ankle monitor. We authorized to take it away.
You bet. Now, I don't have the tools to remove it, but you should be able to reach out to A&A, the monitoring company. And once they know you've been sentenced here, your bond goes away. And so your ankle monitor, have you had it for 3 years?
I've had it since.
Oh, you had it since the FTA.
No, I had it actually since the bond I got for this case.
Holy moly. Okay. That must feel.
2021 when I got out.
Okay. It's coming off. You just need to work with the bonding company. And if for some, not the bonding company, the ankle monitoring company, it's called A&A. If for some reason they give you guff, reach out to Mr. Adams. But once I sign that final disposition, there's no more bond in your case.
Okay.
Last thing we need to sort out with Ms. Tucson is your reporting instructions for probation. Ms. Tucson?
All right, good afternoon. I'll need a good phone number to call and address. That way I could put everything in the system, and then probation will be reaching out to you directly after we speak with your intake information.
I have a quick question. My address is not a question, but my address isn't for Fulton County.
That's okay. You'll just be supervised out of another county.
Okay, my phone number is 470-420-0636. And another phone number is 770-807-2126.
Are these both your phone numbers?
One phone number is mine and one is from my girlfriend.
Which one is yours?
The first one.
470-420-0636.
Yes, ma'am.
And what is her name?
Delethea White.
770-807-2126.
Yes, ma'am.
Okay, and where do you live?
839 Mimosa Drive, Forest Park, Georgia, area code 30297.
839 Mimosa Drive?
Yes, ma'am.
What is that, Clayton?
Yes, ma'am.
Oh, okay. Okay. I will give you a call, and since you live there, more than likely I'm going to have you report to the Clayton County office. So I will call you with those reporting instructions.
Okay.
Sounds good. Thank you, everyone. Good luck, Mr. Harris. I hope you are able to build a deeper relationship with Zach. Okay. All right. Bye-bye.
Thank you. Yes.
Yeah. Sure. Hey, you're here for the Walls case?
I am, yes. I'm with Swift Curry Media and Hires. They asked me to come down and get a little bit of information as his criminal proceedings are coinciding with a workers' compensation claim that we're handling.
Okay.
And we have not been able to get any information on his cases. And so I'm just hoping for any information.
Sure. He is on a trial calendar for November 8th.
Okay.
He'll be here November 8th. Doesn't mean we'll try his cases, but he's been in jail for over a year, so he's pretty high up on the list. That's his next court appearance, November 8th.
Okay. And so that's pretty, he's incarcerated until?
He is in with no bond, and that is not changing until he resolves his two cases. He has one case that I'm guessing you're not involved with, which is drugs and a gun, and then one with some shooting.
We're actually not involved with either of his cases, Your Honor.
Oh.
Neither of the cases that are in front of you, we're handling a workers' compensation claim that he has filed against his old employer prior to the incarceration.
Okay, interesting. All right, that's his status.
Okay, all right, so he'll be in prison with no bond.
So in jail as opposed to prison with no bond, and we'll see him on November 8th.
November 8th, okay.
Yeah.
I appreciate that. Thank
You bet. DAs, anything else? The three amigos, thanks for being here. So what's going on with Emerson? Did Fagan's case go out? Because Olivier's case, everyone pled.
And then Ted Griffin, he got continued.
Because Wolf was claiming there was discovery, but what does that mean? There was a discovery, you weren't privy to that.
I don't think he wanted to try the case.
Right, but